Good morning, it's time for us to make a start. My name's Dan Jackman, and I'm an Assistant Chief Reporter at the Planning and Environmental Appeals Division, and my colleague is Mrs. Lorna McCallum, who is a reporter. We have been jointly appointed by Scottish ministers to hold an inquiry into the Whitesands flood protection scheme and prepare a report for their consideration. Also with us is Mr. Ewan Murray, who is our technician. He's responsible for the sound and webcasting equipment. Before I go any further, I'll just do all the usual housekeeping matters. We're not expecting any fire alarm practices over the next 2 days, so if we hear the fire alarm, it's for real. We should leave by the appropriate exits, and we need to gather in the car park over the road, and no doubt we'll be assisted by the venue staff. Toilets are out in the corridor on the left. Can I ask that all mobile phones are turned off, please? Today, and indeed all the sessions, will be webcast. So if you want to watch yourself on TV tonight, you can Google DPEA webcast. This is the start of a 4-week inquiry. In a minute, I'll explain how we're going to run today's hearing session. Tomorrow, when we start the inquiry sessions, at the beginning we'll explain the procedure that we follow for inquiry sessions. Just a few general points. Our case officer, Mr. Mackenzie, had a great deal of trouble trying to find a venue in Dumfries that was free for 4 weeks. So we're here today. We're here in this venue today and tomorrow, and for the last day on the 7th of December. For the rest of the inquiry, we're in the Johnson Suite in the Holiday Inn just over the road. We will sit Tuesdays to Fridays, as indicated in the programme, and after today, we'll start at 9:30. We will have mid-morning, lunch and mid-afternoon breaks at appropriate moments during proceedings, and we'll aim to finish 5-ish again at an appropriate moment in the hearing of evidence. Following consultation with the parties, we published an inquiry programme. It's very difficult to give timings with any degree of precision. Where we've identified a slot for a named individual, then we will do everything that is humanly possible to respect that slot. We will try very hard to run proceedings to respect the general sessions, but within that, I would ask the main parties who are going to be with us most of the time that we are flexible to make sure that we can keep to the timetable. We're going to be spending a lot of time together. You'll see us about the venues. We're staying locally. It's okay to talk to the reporters, but please, we can't discuss the merits of the case. We would remind everyone that our remit is to consider the objections made to the published order. In preparing our report, we'll consider all the submitted objections, and by consider I mean all the objections will be individually identified and listed in the appropriate topic chapter. We'll also consider all the further written submissions that we've received and all the documentation that we received prior to these inquiry sessions. Last time I looked, we had 1,000 documents. We will be conducting proceedings to focus on the matter before us and what we think we need to write our report. We will politely but firmly remind parties if we think you're going off the track a wee bit. We would add that some people think the purpose of an inquiry is to persuade us of their point of view. It's not. The purpose of hearing further evidence is to help us understand your respective positions. We cannot do our job unless we understand the arguments you're trying to make to us. I can assure you, Scottish ministers will persuade themselves. Therefore, everyone taking part in the proceedings over the next 4 weeks is taking part in a mechanism that is designed to help the minister make the best decision for the people of Dumfries. Before I introduce the hearing session, are there any pressing procedural matters relating to the inquiry overall that can't wait until tomorrow that we need to address now?
Sir, it's really more of a housekeeping point, but for the benefit of the wider group in the room, could I just mention, as I've mentioned to you informally, that there is what we hope is a complete paper set of the documents sitting on the table to my extreme right near the door. These are available to the public or anyone else who wishes to consult a document or check something that someone is referring to. They're not going to be used by any of the council team during the inquiry. They're available solely for that purpose as required.
Thank you. Anything else? Okay then, if we can move on to the hearing session agenda, starting with item 1. Can we go round the tables and ask the parties to introduce themselves, starting with the council?
Thank you, sir. I'm Craig Connell. I'm Queen's Counsel. I represent the council. I'm here so people know who they are as we go along with my colleague Emma Reid, who is sitting on my left. I have with me a number of officials of the council who I won't trouble to take the time to introduce individually. Those who were potentially scheduled for this session have all been identified in the hearing statement, and others will be known through their recognitions. Thank you.
Sipa?
Sir, my name is David McNay. I'm Unit Manager for SEPA in the Dumfries area. I deal with the regulatory side of things, so things to do with the controlled activity regulations. And my colleague on my left, Fiona Naismith, is a senior within that team.
I'm Lorna McLean, Planning Unit Manager for the South West. I deal with the planning side of things and respond to planning consultations.
Yes, good morning, sir. I'm Alistair Cargill. I'm Operational Flood Risk Manager for SEPA. I cover the whole of Scotland with a team of 12 staff, and on my immediate left is Nick Gare, who's the Senior Flood Risk Hydrologist for the South West area of Scotland.
Morning, sir. I'm Steve Matthew, Managing Legal Counsel for Scottish Water, and my colleague is Bob Fleming, who is the Hydraulic Modelling Engineer and Team Leader for this project.
Good morning, sir. My name is Peter Ferguson. I am a solicitor instructed by Historic Environment Scotland. There are 3 members of the Historic Environment team with me, 2 on my left, 1 on my right, and they will each introduce themselves.
Hello, my name is James Brown, and I'm the Deputy Head of Casework for Historic Environment Scotland, and I would be involved in any future SMC application.
Good morning, my name is Tom Parnell. I'm a Senior Casework Officer at Historic Environment Scotland. I'll be happy to answer any questions relating to our previous advice that we've given, particularly in relation to the schedule monument and its setting.
Hello, I'm Louisa Hum. I'm Senior Casework Officer at Historic Environment Scotland, and I'm here to answer questions on listed building consent and conservation area consent.
Morning, my name's Barry Dunn. I'm from Scottish Natural Heritage, and just here to answer any questions on the consultation responses we provided. I was not the case officer, but I'm representing the case officer in this case.
I'm Oliver Mundell. I'm here as an objector, but also as the local member of the Scottish Parliament for Dumfriesshire on behalf of constituents.
Morning, my name's John Dowson on behalf of the Whitesands group. I think it might be useful if you give us a minute just to maybe perhaps introduce everyone. Would that be acceptable?
My name is David Slater. I'm a local businessman.
Thank you. Ralph Coleman, local resident.
Joan Coleman, local resident.
I'm Malcolm Johnson, councillor for Nith Ward, and I'm here as a representative of my ward members.
Ian Crothers, member of Dumfries and Galloway Council, leader of the Conservative group and an interested party in regards to the outcome of this.
Mr. Miller, I thought you might be part of the SOS team. Is that not quite the case? More appropriate for you to be actually sitting at the table rather than standing at the back?
Good morning. I'm Darren Miller, Dumfries man, career archaeologist with particular concerns about various aspects of the scheme.
My name's Alistair Moyer. I'm one of the objectors to the scheme. Thank you.
Okay, thank you. When I direct my questions, I will just refer to the team names. I'll leave it to the teams to decide amongst them who's going to answer the questions, and it's acceptable for the nominated team leader to make some concluding remarks, but I would encourage such remarks to be concise and focused. Just moving on now to the purpose of today's hearing. We wanted this hearing session because we're conscious that there are a number of cross-cutting legislative and policy matters which it's essential for us to correctly identify for Scottish ministers. All of the organisations, like us, ultimately answer to Scottish ministers. So it's very important that we clearly identify who's doing what in the minister's name. Our report will be divided up into topics. The first chapter, as is convention, will be called Background, and we're very grateful for people giving their time to come along today and provide the hearing submissions and the associated documents, which I can assure you have greatly assisted us. In devising the agenda, which we will follow, we focused on those matters where we thought we needed clarification. All your written statements and the documents are evidence that is before us, and we will use in the report So the fact that there may be matters that we haven't included in the agenda does not mean we don't think they are important. We're also conscious that Save Our Sands and Mr. Mundell requested a separate inquiry session on background and context, and we wanted to make sure there was no duplication between the two sessions. So our primary purpose today is to make sure that we come away understanding the correct legal and policy framework within which we need to write our report. For those who are unfamiliar with how a hearing session works, it's a structured discussion that we will lead based on the agenda that we circulated. We will not allow any formal presentation of cases or cross-examination. We shall lead the discussion by starting off directing the question at one of the parties. After the answer, we'll invite the other parties to comment in turn. If you have any comments and questions as the discussion progresses, that's fine, but please make sure they come through me as the chair, and let the party finish the point they're making, even if you strongly disagree with what's being said. In fact, particularly if you strongly disagree with what's being said. You'll see from the agenda that we have questions that are mainly directed at the respective organisations. If it's not your turn, don't feel left out. We'll always check with all the parties before we move on to the next point on the agenda. We shall be adopting a brisk pace. We will move on when we consider we have the information that we need. Don't feel obliged to comment if all you're doing is repeating points that have already been made or are already contained in the written material before us. I know the agenda looks fairly long and detailed. In our experience, actually, once the discussion gets going, many of the points we want answered get answered. So really, the bullet points are more of an aide-de-memoire for us than a detailed sequence of issues that we will have to exhaustively plough through. We will discuss progress as we go along. As I said in my introduction, we'll aim to have a mid-morning lunch and mid-afternoon break. All that you tell us is evidence that we may need to include in our report, and you'll see us take notes. We may have to ask you to pause from time to time so we can catch up. If you're referring to any documents, we have them on a tablet and a laptop, so it's very helpful if you can remember the document name so I can find the right folder I've put them in. Before we move on to the next item, are there any procedural matters that we need to discuss? Is everyone clear? Okay, right, let's move on to item 2A, the Flood Risk Management Act Scotland. And if I can start with the Council, what would you say were the overall objectives of the Flood Risk Management Act?
So, this may be a matter that we'll be returning to in due course in closing, but the general duty which is imposed on all public authorities, including the ministers, is as set out in Section 1 of that Act. Now, the Act talks about compliance with the directive, but I just leave that aside for the moment. The first reference that one finds is reducing overall flood risk. But by submission, sir, that the overall objective is highlighted by that phrase, and there then follows a series of particular obligations which then feed into that overall objective set out elsewhere in section 1. And in addition, so you will also find that that then cross-links to references to any approved flood plan or flood strategy, as it's sometimes called, which has been subsequently approved by ministers. So the Act is about the assessment and sustainable management of flood risk.
Okay, SEPA, any comments, anything to add to that?
Yeah, we certainly support the statement made by the Council. The general aim and purpose of the Act is to improve the assessment and sustainable management of flood risk across Scotland. And it's supported by a new duty on local authorities, SEPA, Scottish ministers and other responsible authorities to exercise their flood risk related functions with a view to reducing overall flood risk as said. And flood risk within the Act, I think importantly, is defined as the combination of the probability of flooding and the potential adverse consequences for 4 key risk receptors: human health, the environment, cultural heritage and economic activity. I think more generally there's an emphasis on working together within the Act. There's a desire to cooperate, to share information and share data with a view towards a common goal, which is the overall reduction of flood risk.
Simply to say that the Scottish Water Support Squad has been signed by the Council and by SEPA. What that means for Scottish Water is that our network has to be designed in such a manner as to avoid creating any further flood risk.
Okay, Mr. Mundell, Save Our Sands, any thoughts or comments on what you've just heard?
Well, just very quickly to say I don't have any difficulty with any of that. I don't think on our side we would have. We understand the duties, the responsibilities. We know the situation in Dumfries. We know the background that's been highlighted. I welcomed the comment there from SEPA about new powers or new suggestions about sharing data, working together, cooperating. And I've certainly read a lot of SEPA's background, which is becoming much more emphasis, I think, on involving communities and businesses that are affected. So we certainly welcome that. That's first class. That's moving in the right direction. So generally speaking, we understand, I think, the background in that context.
Okay, thank you.
Oliver?
Again, I'd fully support all of that. I would just highlight the original policy objective of the bill as set out in the policy memorandum that is designed by focusing on sustainable flood risk management to provide maximum possible social and economic resilience against flooding for current and future generations. I think that is key to what the Act was implemented for.
Okay, thank you. Can I now move on to the next bullet point then? And again, if I can start with the Council. Having looked at the overall objective, in deciding whether to confirm or not a flood order, from the decision maker's point of view, what would you say were the relevant sections that had to be taken into account?
So the primary direction remains in Section 1. The succeeding sections, insofar as relevant to this matter, are set out in the Council's hearing statement. But in essence, what they prescribe, and I will come to your question very shortly, they prescribe a sequence of events which ultimately leads to the preparation of a flood plan or strategy by SEPA, and then a local flood plan, and then in pursuance of these steps, one then ends up back, in a sense, back where one started, because in Section 41, the ministers and other public bodies must have regard to the flood risk plan as approved, and also the local flood risk management plan, so that the sequence is set out in the statute. The objectives are set out in the statute. So primarily the sections that are identified in the hearing statements are.
I wonder if I could direct you to Schedule 2 of the Act, Regulation 6.3. It sets out a series of things that the minister should take into account when he's deciding whether he should call it in for an inquiry. But should that be also a proxy for how a scheme itself is assessed, do you think, or is that pushing it too far?
So these are separate and distinct questions, and my submission would be that the question of whether to call in a scheme is a different question from what matters to take into account once a scheme is before the ministers, having been called in. So it's not immediately obvious that the factors governing call-in are necessarily the ones that will dominate, because one is then thrown back onto the duties that are set out, in particular in Sections 1 and 41.
So your advice to us is that is solely there for the purpose it sets. It shouldn't be seen as a proxy.
Not a direct proxy. Clearly that triggers the fact that it has to be considered at national level, but it's not then carried through and repeated under the question of any consideration once that matter is in the hands of the ministers.
Okay, thank you. SEPA, anything to add to that?
Just on the point regarding Schedule 2, I would tend to agree with that. I think the reasons for possibly calling could be very different to what the guidance in Schedule 2 is directing ministers to consider. I think that's a high-level overview list of generic points that should be applicable to any scheme of any type or scale. In terms of relevant sections for SEPA, certainly Part 1 of the Act, Section 1, the general duty on Scottish ministers, SEPA responsible authorities, to overall reduce flood risk is kind of central to everything we do within flooding in SEPA now since the Act has came in. And we're very conscious of that duty. I think Part 2 of the Act, some of the principal expressions as are related to in terms of human health, environment, cultural heritage and economic activity is important. Acting as a statutory consultee to planning in Scotland, we have to consider both the relevant sections of planning legislation, but we also have to consider the various risk receptors that may be at risk, and certainly human health is important in that respect. Part 3 of the Act is arguably the new duties section for SEPA, and is maybe the biggest task that has came to us from the Act, which puts a duty on us to produce what we've termed a national flood risk assessment, which is a high-level overview of flood risk in Scotland, looking at the various different receptors that are currently at risk from different sources of flooding. Flood maps, that's both flood hazard and risk maps, so hazard being the pure physical source of the flood, whether it be a river flood, a coastal flood from heavy rainfall, etc. And that information ultimately helps on a number of fronts with our duties, but it ultimately feeds into flood risk management plans, which has already been mentioned by the Council. SEPA has a coordinating role to produce a national flood risk management plan for Scotland, which is ultimately reportable to Europe as part of the EC Floods Directive 2007. However, in getting to a position to produce a national flood risk management plan, SEPA is dependent upon each and every council in Scotland. Each local authority is a responsible authority under the Act and has a duty to produce a local flood risk management plan. And SEPA have, of course, assisted the councils in getting to that position through the publication and co-working with local authorities on flood risk management strategies. I think in terms of existing duties, Section 25 of the Environment Act 1995 was basically restated within Part 5 of the Flood Risk Management Act under Section 72. And that relates to the statutory flood risk advice to planning authorities from SEPA when we are consulted on any planning related matters. And that duty we are asked to take account of information we hold and information that we submit. And I would say finally, the other role for SEPA within the Act is that of flood warning, which is very relevant to Dumfries. Previously it was a discretionary power. We undertook flood warning for many years in different catchments in Scotland. The Flood Risk Management Act 2009 made it a duty for the first time. So I think in summary, sir, that would be the relevant sections where SEPA has an involvement with from the Act.
Thank you. Vios, any thoughts or comments on what you've heard?
We've got nothing to add.
So, in relation to the 2009 Act, there is one provision which might have been relevant to Historic Environment Scotland, but ultimately wasn't. And that's paragraph 1 of Schedule 2, which sets out the requirement of the local authority to give notice of the proposed scheme to various parties. Now, Historic Environment Scotland isn't specified, isn't not identified by name in that list. It would, however, have been possible in appropriate circumstances for notice to be given under subsection 4.7. So it's paragraph 1, subsection 7. And under the 2010 regulations, again, there is a requirement for consultation on the scheme and the environmental impact assessment reports. Regulation 2 defines consultative bodies, and again, SEPA, Scottish Natural Heritage, Scottish Water and Planning Authorities are mentioned, but Historic Environment Scotland isn't specifically mentioned. However, under item E, item E does provide for notification and consultation to any other body designated by statutory provision as having specific environmental responsibilities, which in the opinion of the local authority proposing the flood prevention scheme has an interest in relation to the environmental effects of the scheme. So it would have been open to the Council on a discretionary basis to include Historic Environment Scotland.
We'll come on to that later on in the agenda. Anything from SNH? You happy? Right. Mr. Mundell or Save Our Sands, any thoughts or comments on what you've just heard? So your advice to ministers is that although that section is specifically directed to when he decides whether to call it in, nonetheless, reading the Act as a whole, those are sensible points that he should bear in mind. Whitesands?
Could I just perhaps add to that our experience of the local authority is that effectively they had great difficulty deciding to confirm the scheme. And if you look at the minutes of the meetings, you will see that that was far from unanimous in terms of the voting pattern. And the scheme was only agreed to be confirmed by a small number of votes. There were over 300 objections. I don't think any of them were withdrawn. And effectively, because the local authority had difficulty in coming to a consensus themselves, it's our view that they've effectively passed it to the minister and effectively, to some extent, washed their hands of the responsibility.
I want us to focus at this moment on the legal and policy framework, but thank you for that. The Council, do you want to come back on Mr. Mundell's comments there?
Sir, only to say, lest there's any doubt about it, that by way of reminder, Section 1, subsection 2b of the Act itself already says that in exercising their functions, the ministers and others must have regard to the social, environmental and economic impact of such exercise of their functions. So there's already a high-level exhortation, requirement, however one wants to put it, to take account of a range of factors right at the start of the statutory provisions.
Okay, are we done on that? Can we now move on? Just perhaps we can do this fairly quickly, but again, I'll just ask the Council: is there anything in the 2010 or 2017 regulations which you would direct us to, from the decision maker's point of view, as to how we should go about making our decision?
So the regulations are primarily concerned with procedural matters. They are concerned with the requirement for environmental assessment, with which many here are familiar, and the need to carry out an environmental assessment has in fact been done. Regulation 10 of the 2010 regulations does set out requirements imposed on the ministers before they confirm a flood protection scheme, in respect of which an environmental statement has been prepared. But I don't propose simply to read it out. It's there.
For the others, any different views on the 2010-2017 regulations, SEPA?
Not a different view. I think it's just to confirm that the way the 2010 regulations are set out is that the local authority must request a screening opinion from consultative bodies, which includes SEPA, if they think there is not going to be any kind of environmental impact as a result of a scheme. In this case, the Council did consider, and there was an environmental statement which was provided to cover that. So in terms of the way the regs and the bespoke EIA process was set out and how it's meant to work, which is different to planning EIA, I think it was followed correctly.
The other parties, anything on the 2010-2017 regulations? I'm looking, seeing nods. Okay. Now on to B, Planning and Heritage Legislative Framework. And again, I'll start with the Council. Obviously, Section 60 grants deemed planning permission if ministers are persuaded to confirm the order. Does that mean, as decision makers, when one's deciding to confirm the order, that we have to take into account the Section 25 test under the Planning Act, and also Section 59 and Section 64 of the Listed Building Act about the desirability of preserving listed buildings and enhancement of conservation areas? What do you think?
Not in that form, so no, is the position here. What I'm suggesting is that the way Section 25 is framed, it is directed at making any determination under the Planning Acts, and the determination here, albeit bringing with it a deemed planning consent, is a determination under the Flood Act, just to be read short. So I would submit that it's similar perhaps to the electricity type cases where there's a separate statutory regime which brings with it planning permission, but it doesn't directly engage the requirements of Section 25 in that form.
And the two listed building ones?
If there is a requirement for a listed building consent, that, so as we understand it here, sits out with the planning regime, as it would normally do. You would need a separate listed building consent or a separate scheduled monument consent. And therefore, in the initial stages, while the impact on matters set out in the Flood Act, which includes the historic environment, will be considered, the statutory tests engaged under the specialist legislation are not directly engaged.
The reason I asked that question, particularly for those 2 points, is if, I know we're not, but if we were dealing with a planning application, we would have a duty, if a development requiring planning permission had an impact on the setting of a listed building or an impact on the character of a conservation area, Section 59 and Section 64 of the Listed Building Act would apply. Does that mean, in your view, again, those two are not engaged?
They're not engaged in that form, sir, because the exercise that's being undertaken is a freestanding statutory process. That doesn't mean, of course, that impacts on such matters are not relevant to the broader considerations that are driven by the 2009 Act, but one is not dealing directly with the statutory provisions in question. And you know, if one looks, for instance, at the scheduled monument issue, it's accepted that if there is a consent under the 2009 Act and a deemed planning consent, there may still need to be an application under the scheduled monument legislation in due course. And that's, I think, set out in the materials both on behalf of the Council and indeed on behalf of HES. And no doubt there are factors to be taken into account then.
Just to summarise then, so those three sections from the Planning Act and the Listed Building Act your advice is that they're not directly engaged, but that does not mean that they may not be material to the minister making his decision whether shall I say, a material consideration to whether the order is confirmed or not. Or have I gone too far?
I hesitate to get into a semantical debate at this preliminary stage of the inquiry. So if they're not engaged, they're not engaged. But that doesn't mean that impacts on townscape, impacts on historic and important items in the area aren't a relevant factor as is already set out in the Act. It's just one doesn't need to go to the specific wording of the sections and follow any specific test for that purpose. You're still allowed to look at these issues.
Okay, before I go to Mr. Mandel and Save Our Sands, any thoughts from the other organisations? A little bit Anaraki, wouldn't necessarily have to... Oh, Scottish Water, go on then.
Planning is not a particular concern for us. The work that we do is all done under permitted development rights, so I don't think it's something that would necessarily be a consideration for the ministers as far as the work that we do is concerned.
So we would agree with Mr. Connell's summary of the situation. Section 25 of the 97 Act doesn't directly apply, but having said that, given that a confirmed scheme under the 2009 Act would give rise to deemed planning permission, then we would have anticipated that matters which would have been material considerations in a planning context would also be material considerations under the 2009 Act tests.
Mr. Mundell or Save Our Sands, any thoughts or comments on what you've just heard?
I'd largely support the point I made immediately previous. I accept that it's not formally part of the Act, but I do think they provide useful tests, and much in the same way as this hearing and this inquiry has taken place under planning considerations in the absence of detailed tests within the legislation for this particular scenario. I think those pieces of legislation provide useful tests, and I would expect that ministers give due consideration to those points.
Save Our Sands, anything to add?
Yes. I mean, from the earliest, we have raised the issue of the Flood Risk Management Act being used ultimately to obtain a deemed planning permission. And we've had grave concerns about that. I raised that at the pre-inquiry meeting, and you were quite right to advise me that this was not a planning inquiry. However, we would expect any Scottish minister to consider these matters as material considerations. We don't want to see a situation where the Flood Act is being used to subvert basic planning procedures. This scheme is within a conservation area. There are listed buildings. There's Devergill Bridge. These are all material, and we are asking, and we will be insisting almost, that the minister takes these into account, whether they, whether they're in the Act or not. Any minister we would expect to consider them material matters.
Okay, great. Thank you. I'm just now going to go on to the next bullet point, and if I could start with Historic Environment Scotland. And
Can I just add one thing, if I may, very briefly? It's simply in relation to the way in which the interlocking legislation functions, that you may find that one of the reasons why one doesn't simply lift the tests from other statutes is that the general duty in Section 1 is focused on flood risk, and as was pointed out by SEPA, one of the receptors which are specified in Section 3 is cultural heritage. So one is already looking at flood risk and cultural heritage by direction in the Act, and therefore that may be one explanation as to why you don't have a sort of simplistic lift from one legislation to another. But that's simply a very short point.
Okay. I'm minded to move on to the next bullet point then. If I can start with Historic Environment Scotland. If our understanding is correct, and Mr. Connell touched upon this a few moments ago, if the Minister was persuaded to confirm the order, the Council would nonetheless have to apply for scheduled monument consent. Does that mean, from the decision maker's point of view, faced with an order, that the decision maker needs to consider whether there's a reasonable prospect of obtaining scheduled monument consent, or is that a separate, entirely separate matters, and two different consents will just be sorted out? Any thoughts or comments on that?
Yes, the scheduled monument consent process would be a separate process that would, any works to the scheduled monument would need scheduled monument consent under the 79 Act, Ancient Monument Act, and we would determine that in relation to our kind of policies that are set out in the Historic Environment Scotland policy statement under sections 314 to 322.
Yeah, but I'll just push you a wee bit. So, from the decision maker's point of view, got an order, decide to confirm it or not. Would you not have in the back of your mind the prospect of scheduled ancient monument consent being granted? Wouldn't that be relevant?
There are other examples where planning permission has been agreed before scheduled monument consent was applied for, and it would still have to, any works to the scheduled monument would still have to conform with those policy tests. So we would assess that independently, and I suppose there would be three options. We would either grant with conditions, we would refuse, or we could potentially grant with notification to ministers because it didn't conform to our policy, but there is some arching reason why we'd grant that. But it would be, we would have to look at the details of that scheme independently.
If I may also point out that our previous advice, based on schemes as presented to us, a draft documentation, we've outlined the documentation that would be required to accompany an application for scheduled monument consent, and we've also identified that any decision would likely be notified to Scottish ministers, as there's a direction on that we've identified would apply.
That can be specifically found in the HES document 7 annex. No, sorry.
Which one? The circular
letter? No, it's the letter. We set out the 7.
The last letter that outlines this is dated December 2016, which is we've numbered as HES 6 in our appendix to our hearing statement. That's correct, yes, December 2016. That's correct. You'll see under That's correct, yes. And you'll see in our annex there, we've outlined, for example, applying for SMC.
Thank you for that. Council, any thoughts or comments on what you've just heard?
No, sir. This is an issue where I would suggest that the ministers require to be informed of the consideration given to historic issues and other heritage matters, so that they can consider that, first of all, that these have been taken into account and discussed. No doubt in an appropriate case where it's apparent that there was no prospect, perhaps, of some consent was subsequently necessary ever being granted, that might be a different matter. On this side, we recognise that HES, exercising a statutory function, cannot fetter in advance their decision on any such application. But nevertheless, you will hear in the later sessions that there have been considerable discussions. So we would see this as a matter on which ministers should be informed, and they may wish to take into account the nature and extent of the available information as to the exchanges, but they cannot prejudge ultimately the decision on a scheduled monument application.
So your advice to us, it would be wrong for us to apply some kind of reasonable prospect test.
Don't think it's necessary for you to do that, sir, in this kind of case, but it may be that we can return to a discussion of how this actually plays out in reality as opposed to in theory when we come to the heritage session of the inquiry.
Okay, I shall make a note to make sure I ask an appropriate question at that time. Any of the other parties? Yes, Sebastian?
Okay. Well, I'll let, yes.
No, really, all right. What I don't understand here is it's a scheduled monument. It's very, very dear to Dumfries. I speak from my heart here, and many people love that bridge. Many people photograph that bridge. Why it's not been included to HES before now? Because we're now sitting at a public inquiry, and that bridge is extremely important, and it's very, what's the word, integral in what this council want to put on our Whitesands. So the question is, we are here today. So why was this question not asked a long time ago to HES? Because it's so important to the town. It's the most scheduled monument in the whole of Dumfries. It's the most photographed building, and it really needs to be looked after. It's many years old. It's got a Gothic arch. It's so important to the town, and we really don't want to see a large earth bond, and I would assume that HES don't want to see that stuck in front of it either.
Right, thanks for that. I mean, we're going to have an inquiry session on heritage and visual impact. What I'm keen to focus on today is, I don't want to get in trouble with the courts by making an arse of understanding the law. So that's why I'm asking all these questions. So it's a narrow focus on these points. I think you were indicating.
Just quickly, I mean, I do agree with David. We have been trying to get council to make this application for over 2 years, and it just simply hasn't been done. Oh dear. In terms of a reasonable prospect of it, you were mentioning this yourself. We would like to alert you to the fact that we think there's a reasonable prospect that Historic Scotland will refuse the Council's application on the grounds it is contrary to the policies as defined between, I think you said, 314 and 322. And we're quite clear about that. And so any decision that goes to the Minister as a separate process, we will be objecting very strongly to that and expecting the Minister to refuse it.
Thank you. Mr. Lundell?
Thank you. I would take a slightly different view from Save Our Sands, but I'm not 100% sure that I'm clear on that. but I think that it is a separate consideration, and I would want any confirmation from ministers that they wish to proceed with this scheme to be absolutely clear that by giving agreement to the scheme they weren't giving agreement to the monument being altered, and that would be a completely separate process. Secondly, I would have an expectation that ministers, as gently as they can in that way that they're so often good at doing, make it clear that there would be an expectation, if the scheme was given consent, that the council would also look to explore contingencies in the event that it wasn't possible to alter the monument in the way as set out.
Okay. I'm sure we will continue these discussions later on. Have we done all we need to do on heritage legal background? I think we have. Right. Can we now go on to the next C? And let's see if I can take this in short measure. So for the council, you touched on this before. From a decision maker's perspective, in effect, the 2010 regulations require us to take into account the findings of the environmental impact assessment. Are we right?
Yes, sir.
Just in practical terms, what does taking into account mean? What do we have to do to demonstrate that we've taken it into account, do you think?
Now we'll start writing a book on reporters' practice before we get away from the first session. I think it means consider, sir. I think it means demonstrate that you have considered it as opposed to simply noted it in passing. But it doesn't mean that anything in it directs or compels an answer to the question you are being asked. It is something to be brought into the mix. It's an obligatory ingredient in the mix, but it simply comes into that mix. And there may be other factors which drive in one direction or another which ultimately dominate. So take into account means become part of your decision-making consideration.
SNH, would you agree with that?
Yes, in principle, yes. If they take into account and consult appropriately on all environmental issues, accept the advice that they're provided by those statutory consultees, and integrate any survey work or proposed mitigation that we would expect to see as a standard into the plans, then I think we would regard that as adequately addressed.
Okay, any other points any parties wants to make about our consideration of the environmental impact assessment? Looking around, okay. Can I now move on to the next bullet point? And if I can start with SNH in relation to the Solway Firth Special Area of Conservation. The environmental impact assessment concluded that there would be a negligible adverse impact on the SAC, if my memory serves me correct. Is that sufficient for the Minister to conclude that there's no significant effect on the Special Area of Conservation and therefore there's no need for an appropriate assessment?
The boundary of the Solway Firth SAC is approximately 5 kilometres downstream of the flood protection scheme area. The features of interest in this case are sea lamprey and river lamprey, both of which are listed as qualifying features of the special area conservation. So whilst the boundary of the site is 5 kilometres away, those animals are moving into the river to breed. So there be a potential, and it must be considered, whether there'd be a likely significant effect on those animals. Our view is that subject to adequate survey work being conducted, and if any animals were identified in the area, for example, if they were moving material within the river channel, if any animals were found within that area, that they were electrofished under licence and moved, that would be adequate mitigation, and we would not conclude that there would be an adverse impact on the integrity of this SAC site.
Right, I'm going to just take this in steps. So, is there anything before us to say that there will be no significant effect on the Solway Firth SAC?
That's a good question. From my...
Perhaps I can just cut to the chase a wee bit.
Yep.
Normally when this situation arises, for example, in wind farms, we have a consultation response from S&H which says we've carried out an assessment and we think there is likely to be a significant effect, but having done X, Y and Z, nonetheless it's for the Minister to carry out that appropriate assessment. Are we in that situation here, or has there been work that's gone on which means that we're not in that territory?
My understanding is we're not in that territory. The case officer clearly responded to consultation saying there was no concerns in that regard, subject to the correct survey work and potential mitigation work being undertaken prior to the commencement of any work on site.
Okay, so the S&H's view is that there's unlikely to be a significant effect on the SAC.
There's unlikely to be a significant effect. There's unlikely to be a likely significant effect, just to get the terminology correct, on the qualifying features, so lamprey in this case. And if you conclude that and then move on to the next step, which is therefore there'd be no adverse impact on the integrity of the site overall.
Thank you. For the Council, any thoughts and comments on that?
That's our understanding too, sir.
Anyone else on impacts on the SAC? Looking around, okay. If I just now moving on to protected species, and again, if I can start off with S&H just to make sure we've got this right. Looking through the documentation, our understanding is that S&H are satisfied from the conclusions of the environmental impact assessment that there's no need for a protected species licence subject to the carrying out of pre-construction surveys. Have we picked that up right?
That's correct.
Just out of curiosity, what happens if the ministers are minded to grant the order, and then a pre-construction survey comes in and they find some bat roosts in the trees or an utter halt on the berm? What would happen next in that kind of scenario?
In that scenario, if we had a bat roost or if we had an otter halt found within the vicinity which was going to be impacted upon by the construction works, then they would, well, it depends on exactly how it would be dealt with, but yes, in theory, if they were going to impact on those, they would need a licence to do that. And we would agree the details about how they would go about destroying, if it was an otter halt, for example. We would agree the timing of it and how that would be done to minimise the impact on those protected species.
And presumably that's a separate process to the order. You would have to go through the legislative requirements for protected species licence, and if it wasn't grantable, you wouldn't be able to grant it. Is that?
That's correct. We would have to pass certain tests, and if it didn't pass those tests, then we wouldn't issue a license for that.
But in terms of the decision maker faced with the order at the moment, we don't need to consider that at all? That's a separate thing, or do you think we should be considering that?
I don't think it can be considered until you have the evidence of whether or not the species are there or not. Once we have that information, then we can move on to a discussion around are there going to be impacts, and if there are going to be impacts, how do we handle that, and does it pass the tests for us to allow us to issue a license or not?
Okay, thank you. Council, any thoughts or comments on?
Essentially, we agree with what's been said, so this brings out the standard problem with all environmental assessment. If it's done at a particular point in time, in a particular process, it may then have to be updated as that process continues, but at some point a decision has to be made on the basis of the then available information. On the basis of the current information, this isn't an issue, but clearly, as SNH have pointed out, it would be expected that pre-construction surveys would in effect check the position in case something has changed, in which case it will have to be addressed under the appropriate statutory provisions. But at the moment, the Council's position is that this isn't an issue.
Okay, any other parties on protected species? Mr. Mundell.
It was more of a question than anything in particular, but I'll address it to you and you can then decide. I was just interested in what requirement there was, to do any sort of, initial inquiry or investigation as to, as to what species there were likely to be in that section of the river, and whether any of that work had been done, or whether any conversations had taken place between the council and in that regard.
My understanding, that's all in the environmental impact assessment, and the last hearing session we're having is about conditions, and no doubt we'll be discussing what needs to be done in terms of pre-construction studies, etc. Anything else on protected species? Are we done? Okay. Right, if we can move now on to D, if I can start with SEPA. And you must be getting the theme by now. I'm collecting my bits of law. In your submissions, you said there were 4 activities that you would have to license under the controlled activity regulations. Again, as far as the Minister concerned, dealing with the order before them, are they completely separate matters, or would they have to have be aware of the prospects of approval?
They're obviously a completely separate item, in that they require separate licensing under the Water Environment Controlled Activities Scotland regulations. There has been initial discussions with the council with regards to all of these, but we require further details and we need license applications to be made in order to go into the detail of these and ensure that all the relevant information is provided, which hasn't been the case so far.
Just out of interest, when you receive, or if the order is confirmed and you receive such applications, would you consult with other bodies, for example, SNH?
Yes, that would be certainly part of it. Certainly for the licence with regards to sediment management, where there's a possibility of an environmental standard being breached, that we would have to go through an advertising and consultation process. Consultation would be with the SNH. We would have to consider the situation of protected species and the solid firth SAC under that process as well. And all the relevant information would be sought from all interested parties. There could be other fishery interest people that would be concerned, plus other individuals that have an issue with the situation.
Thank you. Council, any thoughts or comments?
Yeah, no issue of disagreement with SEPA, sir. The position is exactly as outlined. There have been discussions. They are fully set out in documents lodged by the various parties, indicating that these matters have moved quite far along. But again, there is a legal process which has to be carried out under a different regime, and that will have to be carried through in relation to the different issues that have been identified. But there's no, insofar as a reasonable prospect test is concerned, which we don't necessarily think is the correct one, but nevertheless there's no indication of an immediate issue on the available information as of now. That's really, but that can't prejudge the final decision.
Okay, anyone else on controlled activity regulations? Mr. Dawson?
Quick clarification on that point. Were you saying that would have to go to a public advert? In other words, would the public, the community be involved in any way?
SEPA, any answer to that?
It would be advertised locally in the local newspaper and in the Edinburgh Gazette. That would be part of the process. So it's there for anybody to respond to.
And you would consider any responses?
Yes, those responses would have to be considered through the licensing process.
Okay, right. Let's see if we can sweep up this section before our first break. I had waste disposal down. If I can just ask SEPA, as we understand it, the gravel that is to be removed as part of the order potentially have invasive species. I think it's plants, and therefore they would have to disposed of in a particular way. Is that something that the Minister needs to address in taking the decision on this order? Or is that part of your regulatory activity in general, so it would happen whatever?
It would probably have to be considered as part of the overall scheme, but any waste disposal, the council would just have to have regard to waste carrier obligations and duty of care obligations. They should be aware of how this material should be disposed of. Certainly for Japanese knotweed, there's quite onerous in how that should be disposed of, and any site that is taken to the operator should be made clear before receiving that that is what is coming onto the site. But that's all down to the council's obligations, so they're well aware of those.
For the council, any thoughts or comments?
No, sir. It doesn't respectfully seem to the council you need directly deal with this matter. This is a matter that's governed by separate legislation. might be the kind of thing that in days gone by one would find in an informative on the end of a planning consent. Having dealt with the planning matters, the consent might then say the applicant is reminded of the need to fulfil their obligations under whatever the particular statute is, and this is the kind of thing that might find a place there, but it doesn't respectfully seem to us that the reporters and the ministers need to consider that because it's governed by other legislation.
Okay, thank you. Any comments, any other comments on waste disposal? Right, can we move then on?
I'd like to ask the gravel.
Right. Well, yes, I've read all that material, and we've been given a lot of information from various parties about what's happened in the past. We can only play the ball where the ball lies, and what we have at the moment is an order, and an order asks for the removal of the berm. Anything else on waste disposal? Right. Whilst I've almost got my full collection of law. For Scottish Water, is there any legislation that the decision maker needs to be aware of in considering the order?
So if I can just go back to the controlled activities regulations for a second, we have already consulted with SEPA with respect to any change to our network, and have been advised that our existing network license would simply need to be varied. So there wouldn't be much work required for us and our car. Any work that we do is going to be under either the Sewerage Scotland Act, 1968. We have a duty under Section 1 to effectively drain our area of surface water and sewerage. So that would be pursuant to that duty. As I mentioned earlier, we have permitted development rights to lay these pipes, or should I say our work would fit under permitted development rights. And we also have statutory powers that we can use for access to land to relocate the necessary sewers or the affected sewers. It's likely that there will be some water mains that need relocated, and that work will be carried out under the Water Scotland Act 1980. I don't think there's anything I can add to that.
Any other comments on Scottish Water's legislative responsibilities in relationship to our order? Okay. The Council, you mentioned, if we move now on to E, the bullet point, you mentioned in your submissions the Climate Change Act. How does that impact on the Minister's decision on the order?
So it's not a direct decision-making provision, but the indications in the schemes approved so far under the Climate Change Act are that attention is being drawn to decision makers of issues such as increased frequency of flooding and so forth, and therefore the Act is if you like, a statutory expression of the issue of climate change and its impact on flooding in particular, and the need to consider issues such as flood protection measures. It therefore provides background to the decision-making process, but it's not a direct driver, if I may call it, on a separate basis.
Okay, anyone else on the Climate Change Act? Are we done? Right. Any other legislation? Have I collected all the bits of legislation I need? I'm looking around. SEPA.
Maybe just useful as a point of clarity, given the design history with flood prevention scheme work on the NIF for Dumfries. So there's a long history of past studies. I think what needs to be kept in mind for those that are not aware is that prior to the Flood Risk Management Act 2009, any design work for a proposed flood prevention scheme would be under the 1961 Flood Prevention Act, and there is a different legal interpretation there. The 1961 Act, there was a legal minimum of 100-year return periods, 1% annual probability design event as your standard of protection, normally with an allowance for climate change. Under the Flood Risk Management Act, it's far more flexible. There is not a minimum standard of protection, which allows local authorities to have a far more flexible approach akin to what is being proposed with the current scheme we're talking about. So I think it's just worth useful background for those who are not aware that there has been a change in the flood prevention legislation.
Any other legislation that we need to collect? Right, I'll move now to item F. I'll just give parties a chance, having gone through the legislative framework for them, if they wish to, you don't have to, you can just pass, but if you wanted to let us know what conclusions you would invite us to draw from the relevant legislative framework that we've just discussed. And if I could start with the Council.
I think if I can summarise it shortly, sir, it is that the primary source of information and direction to ministers on the decision they have is to be found in the Flood Act 2009, and the regulations associated with that is the primary source. That what else we have heard indicates that a range of other matters under other legislation has been dealt with, has been considered, has been discussed, and has been moved forward to sit in parallel to that process. But none of the separate legislative consents impact directly on the question of whether the scheme should or should not be approved. Some of the underlying interests, everything from townscape onwards, may be relevant to that decision, but the separate licensing, CAR, scheduled monument, and so forth, are indeed separate and be left to later.
Okay, SEPA? Don't have to. Can pass if you want. Scottish Water? Historic Environment Scotland? SNH? Mr Mundell?
Just that I would broadly agree with the Council position in that respect, and again I think that the material questions for the Minister are those set out in the Flood Act with particular reference to Schedule 2.
Whitesands?
Well, just finally, although we accept that this is promoted under the Flood Risk Management Act, the ultimate objective is deemed planning permission. So we would still want the Minister to, to take the material significance of these things. It's very important that in any Minister giving planning permission, I would think has to be very, very aware of just what that precisely is in terms of planning legislation. I mean, I'm grateful to the other side for mentioning that within the Flood Risk Management Act there's this issue of cultural heritage, and I think that's an important point in relation to this. So that is in fact in the Flood Act, and I think that should be emphasised.
Okay, thank you. That's cleared item 2. I think it's timely that we take our morning break. If you can come back for 11:45, and we'll start on item 3 when I begin my collection of policies. Thank you. Agenda item, I was collecting bits of law. This time I'm collecting bits of policy. So if we start on agenda item 3, A, and I'm wondering if I can do this in short order. If I could start with the Council, the National Flood Risk Assessment, the Flood Risk Management Strategy, the Local Flood Risk Management Plan, our hierarchy of plans. Am I right in thinking from what you told me this morning and in your hearing statement that the flood defence scheme has to be consistent with the policies set out in that hierarchy of plans?
Yes, sir. And they are all produced in relation to today's hearing. The strategy is BC3 and the local plan is, the local flood plan is BC4.
Okay, thank you. And can I direct a question at SEPA? In the general case, not necessarily this particular order, but generally, how would SEPA go about checking that a flood defence scheme was consistent with the hierarchy of the policies that are in some of the plans that you're responsible to prepare?
Well, as you mentioned, it's kind of a hierarchical process, and firstly, the flooding issues were identified via the National Flood Risk Assessment. So that was first published in December 2011, and that was the first sort of high-level national flood risk assessment in Scotland, and that not just focused on river flooding, but also coastal and surface water flooding. And that then informed the identification of nationally significant areas of flooding, or we've defined them as potentially vulnerable areas. And given the significant flooding issues within the Nith catchment, the Whitesands or Dumfries was reviewed as a potentially vulnerable area. And that then led to help us inform the national the flood risk management strategy for the Solway, which identified a number of key actions at a fairly high level. And one of these actions was, well, two of these actions were strategic mapping and modelling, which has obviously been undertaken, and secondly, a flood protection scheme. And that is in line with our high-level actions recommended for the potentially vulnerable area 1405. And I mean, if it's for informational, obviously these are all available publicly on the flooding section of our website as well. And it was all this process was subject to public consultation and stakeholder consultation as well, and there's been agreement with the Scottish ministers.
I'm just interested in the general case, and because we'll no doubt roll our sleeves up and talk in the detail at later inquiry sessions. But just as a matter of policy, my understanding was that the national plan identified the potentially vulnerable areas, but they're very spatially broad. Most of the central belt of Scotland is a PVA. How do you focus down onto an individual scheme within a potentially vulnerable area?
As part of the flood risk management strategy, there was an appraisal process, and for this we use a catchment area unit. I know there is significant units, but this is a catchment unit, the PVA, and that within the appraisal process it identified that one of the key actions to help reduce flooding overall within the Nith catchment, the lower Nith catchment, was a flood protection scheme. And that would be of in the area of the sort of lower Nith, the Whitesands, Greensands area.
So when I see the PVAs defined spatially, they relate to a subcatchment of a particular river system.
Yeah, that's correct. Yeah.
Okay. Thank you for that. Any other comments from the other parties on the hierarchy of flood risk management plans? Looking around. Okay. Can we? Then I'll start on SEPA for my next bullet point. Apart from that hierarchy that we've just talked about, are there any other relevant flood risk management policies or advice that we need to be aware of?
I think more generally, despite the focus on the drive towards a coordinated approach through the flood risk management strategies and plans, there is enough flexibility within the Act to allow any local authority to undertake works out with that plan. Now, that's not the case here, of course. I'm just illustrating the background, provided it doesn't compromise the overall objectives of the plan. And I think in line with Section 1 of the Flood Act, the overall objective of any planned work would be to overall reduce flood risk. So building a flood prevention scheme in a town that wasn't within a PVA because a flood happened there, would be allowed. And there are policy provisions and guidance that has been made within secondary guidance after the Act to help guide such a process.
What I was really angling at in that question was just generally making sure that is there anything that you're aware of that, for example, sets out a specification for a flood defence scheme, or whether wider catchment management is preferred to hard defences? Is there anything like that that is available that we should be aware of?
Yeah, the notion of a catchment approach is something, again, that the Act seeks to do. It does consider looking across a whole catchment and looking across boundaries, and part of the reason for that was because hydrometric boundaries of rivers straddle administrative boundaries of councils. So sometimes, a river catchment may fall within 2 or 3 council units, and they have to work together. It does recognise the ability for hard defences, traditional defences. It does look at upstream storage, so-called natural flood management techniques, which I have to say are without a great amount of actual credible, tangible, empirical data and evidence to back up the validity of such methods to be used as a wholesale replacement of a hard defence scheme. But they can add to the overall mix of measures. So the legislation is very clear about looking at all forms of sustainable flood risk management, and the policy framework that's been built around about that has given SEPA and the Council duties to consider different forms of measures within their long list of measures that they have to consider for a scheme. But then it is up to the Council. It's not for SEPA or for ministers to tell them. It's up to the Council to then hone in that long list to a short list of measures and do the analysis in terms of cost-benefit to take forward what they think is a viable option for the protection of people and property in their area.
Okay, thank you. Council, any thoughts or comments?
I don't think I have anything to add on that discussion, so.
Any other comments on flood risk management policies? Looking around, Mr. Dowson.
Yeah, could I just comment on? I've got something called Delivering Sustainable Flood Risk Management 2011, which gave guidance, and that was particularly about the involvement of local communities. It talks about...
Do you have a document reference there, please?
No, I haven't, no.
Is that something before us?
Yes, it is in your list. I'd have to find it for you.
If you'd just let us know.
Yeah, I'm sorry. This is a wee bit of inexperience on our side. I apologise for that. But this document gives guidance to, and I think it's to SEPA, on, it effectively talks about a top-down approach that disengages local authorities and local communities from decision-making must be avoided. There's a whole range of guidance in there about how communities should be involved in actual decision-making. So these are policies, I think, that are fairly new to SEPA or coming into SEPA. We welcome them, but I think, you know, we feel that they have not been implemented locally and should be. I don't know if SEPA want to maybe comment on that.
Hang on a second. If you could let us know on the previous what that document was. That wouldn't be the one published by the Scottish Government as guidance to SEPA and councils, would it? Yes. Yeah. Okay. I think I know what you're referring to. Yeah, I think I know the one you're referring to. Okay. Mr. Mundell.
I think that's where the danger of duplication comes in, because I was just going to ask SEPA if they could set out their policies really, or ministers to take note really of SEPA's policies on community engagement. And the second thing was again more a question than a statement, which was about any advice as a matter of policy that SEPA provide local authorities with when it comes to prioritising different schemes. So as in whether the scheme would take priority over other schemes in the region, or you know, in terms of the council's focus.
Did you note that, SEPA? One question, let's do each in turn. One is, does SEPA have any policies in relation to community engagement?
Yeah, to answer the original question, I mean, the policies and the guidance that was referred to, I mean, SEPA is actively involved in helping write that guidance with the Scottish ministers. With respect to flood prevention schemes, we need to keep in mind that SEPA are not the flood prevention authority, it is the local authority. And we work with them, and we work with local stakeholders through the local flood risk management plan area groups that have been set up across Scotland to engage as many stakeholders as possible. And SEPA has been, well, one of the duties we were given, one of the key roles was to be the facilitator of that process. And everything that we have that's published on that is on our website. But at the end of the day, when it comes to flood prevention, the legal duty is with the council. And as I said, it's not for SEPA to tell the council. We work with them and advise them. They produce their shortlist and go for a particular option. And then once they decide on that option, then there's a process of consultation, which includes ourselves. Just more generally on the point of the public, I mean, we are a public body, we provide a public service on a number of fronts, and we do have in place a dedicated flood comms team and a dedicated pool of flood advisors that cover the whole of Scotland, who are constantly working with locals and through Scottish Flood Forum and other bodies to help and advise people on information. Whether it's to do with the design of a flood prevention scheme, whether it's to do with making yourself more resilient to flooding, or how you recover after a flood. So we are widely engaged in that, and again, there are a number of policies and guidance documents that cover all that aspect of the work.
Okay. Okay, thank you. I mean, what I took from that, from Mr. Mundell's question, was that your focus in terms of community engagement is working through the flood area groups, as well as all your national work, and you don't have any specific advice in terms of prioritising schemes, but you give general advice to councils. Did I pick you up right there?
Yeah, apologies, sir, I missed that point. SEPA do actively work with the Scottish Government. We have a team of officers who are involved in a process which is led by the Government's flooding remit group to actively look at all the different flood prevention schemes, all the designs that are submitted under Section 60 of the Flood Act, to try and prioritise. And within the recent or first round of prioritisation, in the first iteration of this process since the Flood Act came into being, I think the Whitesands scheme was ranked as number 18 within the process. And of course, we've now moved back to the grant and aid scheme, which was deviated from for a while when single outcome agreements were brought into force. And the grant and aid basically talks about schemes that are approved. It's 80% funding from the Scottish Government and 20% by the local authority. So it's those schemes that will be on the priority list who will be obviously eligible for such grant and aid funding.
Right, well that was a very interesting response. I don't want to distract myself, but so separately to the order process and separate to our inquiry, there are officials within the Scottish Government who take an overview of all the scheme in order to prioritise Scottish Government money. But that's a separate process to the order. So the order could be granted, but the government chooses not to give the money. Could be. Okay. Mr. Mundell, does that answer your questions?
It starts to answer them. I just wondered, in terms of, without being picky, in terms of that process which put this project at number 18 on the list, what role community engagement played in part of that prioritisation process? As a matter of policy.
Yeah. Was that just an internal review, or was that subject to consultation?
Well, in line with after the identification of the scheme, we were involved in back from 2012, we were involved in the charrette process and things. So that's when there was community engagement undertaken from the council, and other key stakeholders in the public were involved then.
I think what Mr. Mundell was angling at was who was anyone else? Was the public involved in deciding it was 18 out of 42, or was it official based?
Yeah, it was officially based. Yeah. Scottish Government and ourselves.
Okay. Answered. Okay. Right.
Yeah. Could I just? It's really just to ask SEPA a question in the sort of introductory piece there. They completely ruled out flood risk management through upstream floodplains because there was no empirical evidence. But there is in Dumfries. In 2015, the Whitesands flooded quite severely, and all of a sudden the flood level dropped several inches, maybe up to a foot, and people wondered why, only to discover that somebody had taken a digger and gone to the Dulscoin Bund, broken it, and brought the Dulscoin floodplain back into play, and that had reduced the flood level in the sands by about a foot. But now, is that not empirical evidence? Thank you.
I don't want us to duplicate. That's your evidence in your recognition, which we're considering at the technical inquiry
at the moment,
assessment. Though. No, hang on a second. The focus today is about the legislative and policy framework. SEPA made some comments there which I noted and you noted, but I don't want us to get distracted into debates about hard or soft solutions. That's not the purpose of today. Any other questions on the flood risk management policies?
Yeah. I'd need to ask again, is that comment a policy or is it simply a comment? That is my question.
Fine. SEPA, do you have a policy? Do you have policies on soft or hard solutions?
Yeah, SEPA does have a policy to try and encourage the adoption, or certainly the looking at natural flood management. I wasn't specifically referring to necessarily embankments. I'm well aware on many catchments across Scotland of the benefit and also the disbenefit of agricultural embankments being in place. The problem with agricultural earth embankments is you cannot guarantee whether they're going to overtop, fail or not during a flood. So there is no certainty with them. So to actually use them as a formal means of flood defence is difficult.
I'm really worried that we're going to stray into technical topics which really should be part of the inquiry. You mentioned SEPA did have natural flood management policies. Could you direct us to those documents before us? Or provide them if they're not already before us?
So just while that's being done, the document that Mr. Dowson was referring to is 32 of the documents produced by SOS.
Yeah, we haven't actually provided the NFM guidance, but we can do that.
Could you do that?
Yeah, that's fine.
Would there be any objection to that from the Council?
No.
Any objection from Save Our Sands? If you could provide that to the case officer, and we will think how we will get that round to the parties. Thank you very much. Any other points on flood risk? Mr. Slater.
Okay, that's fine. So I press it twice. I'd like to ask SEPA regarding DEFRA, Environment Agency in England and Wales, why they are far more further forward in their consultations with the public and other stakeholders as such, because it doesn't seem to be happening here. DEFRA are more involved with the flood defence systems there and even help design and build them. It doesn't seem to be happening in Scotland. And one other point about your earth bonds, you're quite right, they can be overtopped. And I'd just like to point that out, they can be overtopped.
Right, I don't think that was a question. That's your opinion. DEFRA does things better than SEPA. We do have SEPA is the agency who are here today, and what we're focusing on is relevant policy frameworks. Are there any other flood risk management policies or advice we need to bear in mind? Okay. Can we now turn on to B then? Planning and heritage policies. I listed out there in the bullet points the top four, the ones that have been frequently mentioned in the hearing statements. For the Council, bearing in mind what we discussed this morning, would I be right in thinking that those documents are material considerations for us to take into account?
Yes, sir, at various levels of generality depending on the individual document in question, ranging from very high level, for instance, the planning framework, down to a much more local level in the Whitesands master plan.
Are there any? Have I missed any from that list?
don't think there's anything in terms of direct planning policies that we would add. So obviously some of the processes have had things like SCA applied to them and so on, but that's a slightly different issue.
So that's not a bad list to start with. It's got the main policies. Any other comments from the other parties in terms of the planning and heritage policies we should be aware of? I'm looking around. Heads happy? Hang on a second. Let's just...
So to clarify at this stage, are we simply identifying the relevant policy and guidance, and we will move on to how that should be applied in the next section?
Yes. I hope people have cracked the code in terms of the agenda, that we were looking at law, then policy, and then the relevant tests which combine the two together. So I'm collecting policies. If there's any other, I'm very happy to... Oh, I've missed off. No, I haven't. I have included yours.
So the policies are identified in the bullet points. There are, however, two documents which are guidance, which aren't specifically mentioned in the agenda, but which are mentioned. The first of which is mentioned in Historic Environment Scotland's hearing statement, and that's the Historic Environment Circular 1, which is document HES 9. There is one other document which we omitted to list in the hearing statement, and that is a document published by Historic Environment Scotland titled Managing Change in the Historic Environment Setting. Now, this is a 2016 document which provides non-statutory guidance as to how policy should be interpreted and applied. With your permission, sir, we will lodge this as an additional document.
Any objection from the council?
No, sir.
Save our hands?
Nope.
That would be helpful. You and I both know that I'm familiar with that document because the last time we met, we discussed it in some depth. Okay. Anything? Right. Save us.
Just simply to mention the conservation area status of the area. I would have thought that was a policy or
Yes. We're aware it's a conservation area. Yeah, absolutely. Okay, anything else on planning and heritage? If we've done that, okay. Can we now go to wildlife and habitat policies? For S&H, are there any particular policies in related to protected species or impacts on habitats that you would check that we were aware of?
Not a particular policy per se, but there is web guidance which is referred to in the S&H submission, which covers protected species licensing, which I think would be the follow-on issue that we discussed earlier on, which would be considered later on. I'll leave it to you to consider whether or not you need to examine that more closely as part of this process, or whether all of that would be dealt with post-inquiry decision. It wasn't submitted as a document per se, but it was referenced in our submission.
I'll think we'll think about it. We'll be in touch if we do.
That's fine.
Anything else on wildlife and habitat policies? I'm looking around. Okay. Anything, same kind of formats? Anything we need to know in relation to pollution control and water industry policies, apart from the guidance that SEPA had already included in their statements?
I think everything's listed in our hearing statement with regards to regulatory methods and support and guidance. Not aware of anything else to add.
Okay, Scottish Water.
I think that's the same position we've already lodged. There is only one other policy that we may consider, but I don't think it's entirely relevant to this scheme, and it deals with internal sewer flooding. So as part of our design we would look at that. But as I say, I don't think that's entirely relevant to the decision here.
Okay. Any other points on pollution and water industry policies? Everyone's saying I've got the full set. Any other policies and guidance? Are we done?
Yeah, could I just refer to some of the work that's been done in the Scottish Government at the moment on things like the Community Empowerment Act. I mean, this is to, again, stress community engagement. And also a consultation document that's out at the moment called Democracy Matters. I think Aileen Campbell, MSP, as Cabinet Secretary, is currently consulting on that. And in terms of guidance, broad guidance, in this building 3 or 4 years ago, John Swinney, MSP, made a very clear piece of guidance and statement in which he said the Scottish Government weren't in the business of funding schemes that did not have community support. And I think that's one of a very important piece of guidance that we should all be aware of.
Okay. Have I collected my policy? So at the same format again. You don't have to, but F is an opportunity for the parties to invite any overall conclusions that they thought that we should draw from the relevant policy framework. If I could start with the Council.
Thank you, sir. Only very briefly to reiterate the point made before that the Act is a flood Act and is primarily directed at that, and therefore the first port of call is consistency with the steps taken under that Act at the different levels of hierarchy, and that our submission is the starting point. Thereafter, the other issues such as policy, general policy, local plans, and so on, all feed into the broader considerations that are already required by the Flood Act.
SEPA?
Yeah, I would probably agree with that. We do have a slightly different role, however, in that we have the regulatory side, which my colleagues have talked to. So, yeah, I think for the most part, it is a Flood Act in terms of the scheme. There's a small planning element in that. With the deemed planning permission, there would still be scope to comment on the conditions, possibly, Lorna, I would think. But yeah, I think the car regime and the regulatory side, as my colleague has explained, is a separate process which we've still to look at.
No. Hez?
Well, only to reiterate that matters which would have been relevant had this been a planning application, matters relevant to cultural heritage and the historic environment should also be treated as material considerations for the purposes of the scheme.
SNH? Mr. Mundell?
Thank you. I would just go back to the discussion right at the beginning and the importance that the Flood Act places on social and economic factors. I think its decision to stress those does bring all of these other policies into play, and there are very broad duties and considerations that have to be made by the local authority in bringing forward a scheme like this, and it's right, therefore, then, that Scottish ministers interrogate every aspect of that case. Secondly, in relation to the comments from SEPA, I would be concerned just that the process of identifying Scottish Government funding appears to be in part linked to this process as well, and I don't think those two things can be seen as entirely separate And I think that does then bring in further aspects of policy into question.
Save-Our-Sands? Okay, thank you. Right, if we can now move on to item 4, and we may be able to do this fairly quickly, having done the legwork previously. What I want to try and do is pull together the comments our discussion on both law and policy, because very often when you combine these two things, from a decision maker's perspective, there are some kind of test or duty that has to be followed, or a certain sequence of events that a decision maker should follow. So I'm keen to get parties' views on what those should be. So if we try and break those down into the subject matters listed in the agenda, if I could start with A and the Council. When it comes to flood risk management, are there any tests or duties that we need the Minister should follow?
So the danger in answering that question is that you simply gloss the words of the statute, which are what they are. In the statute, the word must is used on occasion, so that's an obligation on ministers. For instance, must exercise their functions with a view to reducing overall flood risk, or must take account of have regard to certain things. And then there are others which are, as I say, are in the have regard to camp, such as the social, environmental, and economic impact of the exercise, and likewise, as we touched on earlier, in the regulations, which list things that you must or must not do. But it respectfully seems to me that there is a potential risk in creating a separate, sort of freestanding menu of obligations, which is not simply gleaned by having the Act in front of you and noting the different points that arise. I'm not sure that's a particularly helpful answer to the question that you asked, but consistent with the Council's position that this is primarily a scheme under the Flood Act, and therefore the primary source of obligation is there. That is the Council's position, I think.
Okay, thank you. SEPA, any thoughts or comments on whether under flood risk management, in terms of the legislation and policies that we have been talking about, whether there is any duties or tests the Minister must follow?
I couldn't add much more than what the Council just said. I think the fact that the main driver for the scheme is the Flood Risk Management Act, I think there is a duty on Scottish ministers to reduce overall flood risk, which has to be made with respect to the 4 key risk receptors, which include cultural heritage in this case, as we've talked about, but human health, environment, and economy are all important, and there's not an official hierarchy of which one is more important than the other. That probably has to come down to a site-specific examination of a case-by-case basis, whether it's a planning application or whether it's a formal flood prevention scheme, as in the case here. So there are duties that the Scottish ministers have upon them in terms of both the Flood Risk Management Act and various parts of planning. That's all I'd like to add. Anybody else?
Scottish Water? Mr. Rockingham, Scotland.
So, but beyond noting that the definition of flood risk includes cultural heritage as one of its components, we have nothing further to add.
FPS-170 or Mr. Mundell?
We've mentioned the test of community support. I think that's very significant, as outlined by John Swinney. The other one I would want to see the Minister being satisfied about was that there had been a robust and fair and detailed option appraisal process. The Minister should be satisfied that that has been done thoroughly and properly.
Okay. Mr. Mundell?
Yeah, I would just again come back to the policy intention behind the Act, and I think there is a focus on social and economic factors, and I think there are broader public interest tests that the ministers are exercising when it comes to the use of taxpayers' money, and whether or not the scheme offers good value, whether or not the scheme has public support in the community, and where it sits within that prioritisation list, both locally and across Scotland as a whole, whether or not this particular scheme should be brought forward at this time, I think is a question that inevitably arises both from the Act and in the Minister's broader duties.
Okay, I think we're getting to a consensus, so I'm going to jump immediately. I don't think anyone's going to be adding anything to B, C, D, and E, so I'm going to jump immediately to F and invite the parties to give us your conclusions as to how we should advise the Minister to decide in legal and policy terms whether to confirm the order or otherwise. And I'll go around again. It may be you can just refer to what you've said already. For the Council, is there anything else you'd want to add?
I don't think there's anything, sir, that really adds to what has been said earlier. Inevitably, some of the topics we have discussed overlap one into the other. There may be a question. Mr. Mundell has raised the issue of funding. For the Council's part, not satisfied that that's a relevant factor for the determination of this application. The other provisions have all been identified, and consistency with the different factors is important. But I think otherwise I'm going to go back and repeat something I've said already, which there's no point doing.
SEPA, are you happy that we can explain to the Minister what he has to do in order to consider the order?
Could I just raise the issue of the fact that there will be certain activities undertaken under the regulations as part of this. There is a possible likelihood of a failure of an environmental standard with relation to one of these aspects, and we would have to look at going down the derogation determination. So it's just to highlight that aspect. The regulatory methods, support and guidance is all laid out on how we would have to go through that process.
Scottish Water. Hez?
So there is one point which we may come on to in the next section, and this may well be well understood by you, but I didn't want to miss the opportunity to make the point so that you can make a note of it at this stage. Any impacts on the setting of the bridge or other assets will only be taken into account as part of this process. The impacts on the setting of the bridge will not be covered by the scheduled monument consent, listed building consent, or indeed any other consent.
Okay. SNH. Mr. Mundell.
Thank you. I think that's an interesting point that's just been raised, and I would just ask that that be noted. It certainly wasn't something that had occurred to me previously. I would simply sort of repeat the comment that I made. I think the question fundamentally for the Minister is this scheme in the interests of the town and the interests of the people who live here? And part of that for me is certainly asking about whether or not it offers good value for money and is supported, because ultimately public money is not, is finite, and government ministers have to make decisions about how best to deploy the resources available. And in doing so, I think they have to ask all of the questions and answer all of the obligations that are placed upon the council. I think the ministers have to put themselves in place of the local authority and ask whether or not all of the issues and questions that Flood Risk Management Act raises have been satisfactorily answered.
Okay, Sailor's hands. That's good. Right, if we now move on to item 5, and if we, what I wanted to then to run through the roles and responsibilities of the respective organisations, just to make sure we understand who does what. So we'll be directing a series of questions at the particular organisations. If I can ask the council and the objectors to be patient whilst we run through, but I'll always come back to you before we move on to the next one. We'll see how far we get before we break for lunch. So, SEPA, you're first up. So if I can ask, in the general case, how does SEPA go about testing a flood defence scheme that you're consulted upon? What do you actually do?
Well, first and foremost, on the outset, we, as the Hydrometric Authority, would, where available, provide river and rain gauge data. And we have, in this case, several river and rain gauges that we have provided in support of the hydrological modelling and also subsequently the model calibration process. After that, we would then have some initial discussions with the relevant consultant in terms of the overall schematization of the hydraulic model in support of a flood protection scheme. And that would initially confirm the baseline scenario, so assuming what is currently there, and then we would review that, which we have done in detail, and all our review processes and our responses have been provided in our hearing statement on the website, and after which we would then look at the options appraisal undertaken by the consultant and review that in terms of ensuring relevant options have been considered and the effects and impacts of those options have been assessed appropriately in our opinion. And based on that, we would then provide some response to the council in terms of our advice in relation to the modelling and the proposed scheme, which is what we've done in this instance.
Okay, thank you for that. I think you've answered that one already. I think you've answered that one. So when again, I want to stress this is the general case. How do you generally deal with flood defence schemes? Would it be your practice to actually assess independently yourselves the alternative options that the council, that a council looked at, and give your own view as to what you thought was the optimal option, or would you just be screening out options that, in your view, were poor?
I mean, if we thought an option could be appropriate and it hadn't been considered, we would be contacting the council and saying that option should be considered.
But when there are various options, does SEPA itself pick one that it thinks is the best, or is it that you just screen out ones that you think are unacceptable?
We would, yeah.
You could be saying, well, you know, there's 5 options, 3 could work, 5 would be a complete duffer, 4, or you could be saying, no, of the 5, we agree that number 1's best. I mean, how do you actually deal with it?
Our advice would be what we consider is the most appropriate option or combination of options to provide the most sustainable flood management for that area. So in this case, we believe that the current proposal is the most appropriate from a flood risk management perspective. And also in terms of considering the cost benefit as well.
Okay, thank you. In the general case, would it be your practice to flag up any concerns if you thought they had implications for other regulatory areas?
Well, in terms of just purely on the flooding perspective, if we had concerns, yeah, we'd flag it up, and indeed through our model review we had queries on was getting more technical, but there was a few technical questions in terms of specific coefficients and roughness values, and they were addressed with discussion with the council and the consultants.
What about other regulatory areas?
In more general terms, we would also consult hydromorphology for their comments. Usually ecology, depending what was contained in the environmental impact assessment, and also our regulatory team and aspects of the scheme that needed environmental authorisation.
So in the general sense, you know, SEPA is speaking with all its different interests. It's not just one bit of SEPA.
Yes, we would consult all the relevant internal consultees.
Thank you. I've got a question on models. I'm sure you appreciate that we have a technical inquiry session. We're hearing from the council's witness on that. But just in general terms, I had always been given to understand that hydraulic models are very useful tools, but they should not be seen as perfect predictors of complex natural events. Is that fair of me?
Well, naturally, yeah, the model, it's a mathematical model, and it's, by an essence, it's a simplification of reality. And there's various components that underlie the construction of the model. such as the hydrology, which has uncertainties in itself, and also the topography, which again has inherent uncertainties. But all we can do is try and ensure that the most up-to-date information has been used where possible, which in our opinion it has done. And also in terms of, you can try and help assess that uncertainty by providing something what we call our freeboard allowance, which is specifically for taking into account uncertainty, and a robust freeboard assessment has been undertaken in support of this flood protection scheme. And also it's probably worthwhile noting that model calibration validation has been undertaken using several historic flood events, most recently the December 2015 flood event, which was the highest on-gauge record within our network on the NIF, and that was used to help calibrate the model. So essentially we're viewing that as the model as the best available information on flood hazard within the Lower River NIF, and we're using that operationally for our land use planning purposes at this moment in time. And we're also using the model to update our existing flood warning schemes for the River NIF, which is one of our actions under the Flood Act.
Okay, thank you. And when it comes to, again, in the general case, when it comes to assessing hydraulic models, what sort of degree of confidence do you expect from an acceptable model? Is that impossible to say?
Within our technical guidance documents that we've referenced here, there is specific parameters in terms of comparing observed against modelled water levels and comparing the hydrograph peaks and things. There's minimum criteria that we would accept in terms of differences between the observed and modelled water levels.
Could I just ask you to take me to that to make sure I see the right bit? Can we just have you got that before you?
The specific document is the flood modelling guidance for responsible authorities, but I can't remember off the top of my head that specific section, but I can provide that section to you if that would be of use.
Right, so the one I was going to go to was document 26, flood modelling guidance for responsible authorities?
That's correct.
Yeah, okay. Right, if I put it on my tablet and gave it to you, can you find it and tell me what it is after lunch?
There will be an extra copy of that available in hard copy, if that helps.
Right.
Could I? Sorry.
Right, that's all my question.
I was just going to add further to what Nick's explained very well. Yeah, the whole science of hydraulic modelling is rather technical and complex, and it has improved remarkably over the years. There is an element of uncertainty within hydraulic modelling. There are certain natural processes in a river that cannot be fully replicated. However, any hydraulic model worth consideration is a model that's been well designed, taken into account the full cross sections of the river, all the structures. It uses observed gauge data, which we have provided, as Nick says, and has been calibrated, as Nick also said. I think that's a key point. If you're able to calibrate a model so that it is replicating an observed flood event level from the past, then that provides a whole degree of extra credibility to a model. So whilst it could very easily be seen as a crude representation of reality, the fact that we've actually calibrated it to real events, as has been done here, provides a lot more weight and justification as to the levels of uncertainty or not involved with the model. So the guidance document you refer to is rather a lengthy document and covers the multitude of, it's a multifaceted project in itself, and there's lots of elements to it. So, in terms of the knowledge and skills required, it is quite an onerous task to review such a thing. But I think, and I'm very confident that the guidance that we provide and have done for years covers the key elements, and certainly the detail and scrutiny which we actually gave to the examination of this model was certainly notable.
It's just if there are parameters, it's much safer for you to tell me which bit of that document I should look at rather than me to try and hope that I find it. No problem. Okay, for the Council, any thoughts or comments on what you've just heard?
I don't think there's any element of disagreement between those advising the Council and what's just been said by SEPA over the nature of the process that's undertaken. I suppose the only point here is that, as far as the Council are concerned, the use of models appropriately checked, assessed, calibrated is, as the Council understand it, the standard methodology to be deployed in any consideration of a significant flood protection scheme or similar issue. So that while no doubt must be acknowledged that no model is perfect, and so you'll have seen different models on different topics in your day, this is the industry recognized, nationally approved, whatever one label likes to put on it, methodology for assessing matters for the purpose of fulfilling the statutory functions which are then imposed on the various public authorities.
Mr. Mundell? Yep.
I'll go first, John, and then I had a couple of questions that just arose. My first one was really what duty there is upon SEPA to consider suggestions that come forward from objectors or members of the public, and what role they played in helping the Council draw up their responses to objections. I also wondered how many models the Council had brought forward, and whether they brought forward models on all of the options that they've consulted on over the years. I also wondered how many designs, not just models, but how many scheme designs the Council had asked SEPA to look at. I think those questions are relevant because SEPA have given a view on what they see to be the preferred choice. The next question was around how SEPA, what factors SEPA took into account when coming to a preferred option, and just clarification over whether that was a preferred option based on the technical data, or whether they took into account, for example, a duty to consult the public and take other views, wider social and economic views into consideration. And the final one was a technical question around the modelling, and that was to ask about the tidal nature of the river. Obviously, by pegging the model against a single flooding event in 2015, certainly from my very limited experience of flood events, because of the tidal nature of the river, there's a possibility that where the tide is at a particular point in the cycle, when that flooding activity is observed, it can change quite significantly the modelling that's required. I just wondered how that had been taken into account.
Thank you for that. I will allow those questions. I think you're going to have to help me reiterate them, and I think, to be fair, it's a severe memory test for SEPA there. So let's start with the last one first, if you don't mind. I'll try and paraphrase it, and you keep me straight, Mr. Mundell, if I don't get it right. But the last question was how the model had dealt with the tidal nature of the river, if there's an easy answer to that.
Yeah, so any model needs an upstream boundary and a downstream boundary, and Mr. Mandel's right, for the downstream model boundary, a tidal boundary has been used, which is what we'd expect given the potential tidal nature of parts of the Nith. And on that, what I can say is that sensitivity analysis was undertaken on the tidal boundary condition to determine how sensitive it was, how sensitive the model was to potential changes in the tidal data, and it was viewed as not being a significant factor in terms of influencing water levels within the flood protection scheme area.
We'll be considering in more detail the technical details of the model at the technical inquiry session.
I'm just concerned, sorry, that SEPA won't necessarily be available for question at that point, and I had one very small supplementary to that.
If it's really very small?
It is very small. It was just to ask, obviously you talk about within the tidal element wouldn't have any impact within the flood prevention area, the area the scheme covers, but is there any possibility that it would have an impact in areas just outside, or because we're talking about a sort of quite a significant downstream area where there's already existing flooding, for example, in Kingham, where the water already crosses over public highways.
Well, from our perspective, if something was viewed as potentially significantly increasing flood risk, then we would raise concerns about it. So in our opinion, we don't think that the proposal will significantly increase flood risk downstream or elsewhere.
Thank you. So your fourth question was, when SEPA comments on a model, are they just looking at the technical issues, hydrological issues, or do you factor in other impacts, for example, impact on cultural heritage, if I got that right?
Well, my job as a flood risk hydrologist, I'm purely focusing on the flooding issues, so the technical side in terms of the hydrological modelling and the hydraulic modelling, and obviously if there's any increases in terms of levels, then we would expect that to be considered.
So it is just the technical set. You're leaving it for others, whether other impacts outweigh the benefits as you see it in terms of the flood defence scheme. Is that right?
Yeah, I mean, we work obviously closely with our planning colleagues. Maybe Lorna would want to say something on that. But on the whole, the overall response that would go back would consider any impacts that there could be, if there were significant impacts on any risk receptor involved. So the overall SEPA response, which might have 2 or 3 different scientific departments feeding into that response, would try and put our overall advice into some kind of context relative to our wider duties. So just for example, there was another scheme in Scotland up north, which I'll not mention by name, which we objected to strongly years ago because there was an increase to properties downstream, a very severe increase to properties downstream. And we highlighted that risk to human health, for example. So, yeah, these things will be considered within the overall.
But that's right. But you wouldn't extend that to, for example, loss of car parking.
No. Our overall comments on the flood protection scheme would concentrate on flood risk and environmental impacts, and it would be for the council to consider other material considerations.
Okay. Right, you may have to help me on question 3. I think that was how many scheme designs that SEPA looked at?
It would be good to get some clarification as what a scheme design is actually. What you define as a scheme design, please?
I've certainly only seen one scheme design brought forward by the council, and that's the one that's under consideration as part of this inquiry. have seen through the consultation some other ideas, but not set out as detailed schemes with a mock-up, for example, or some visual representation of what they would look like.
Well, I think we need to confine ourselves to the things that are in the order before us. As I recollect from the design justification, there were various options that the council put forward. Perhaps you could tell me how you looked at, which might help Mr. Mundell. You could tell me how you looked at those particular options that were actually put in the design justification to the order.
Yeah, I mean, you're right. There was, as expected, there was a number of options considered before a finalised design was proposed. And again, those options were considered either in detail in previous modelling by Michel in 2011, or more specifically in detail in the latest modelling. So in terms of what we'd be looking at, we'd be looking at the natural baseline conditions within the assessment area, and then we'd look at the various model runs for the various options under consideration. We're looking for various cross sections and the potential impacts on water level, and if there was significant impacts on various options, then we would have expected them not to be considered, and obviously then we'd be looking for the most appropriate option or combination of options to be undertaken.
In terms of the matter before the Minister, we have an individual scheme, and you were consulted formally on that individual scheme. When you commented on that formally, presumably you could only assess that individual scheme.
Yeah, that's right, yeah.
Okay. Is that, am I getting somewhere? And I think the second question was, how many council models have you looked at?
In relation to this scheme, well, we looked at the initial Jacobs one in 2006. We looked at the initial Michel model in 2010, the updated calibration report and modelling in I think it was 2015, and then the finalised modelling and preferred scheme option design in 2016, 2017, I think it was.
Okay, thank you. And then the first one was, I think it was, you have to help me, Mr. Mundell. The duty of SEPA to consider public comments when they're making their comments, was that?
Yeah, and just how they had considered suggestions from objectors, and whether or not they had been in dialogue or supported the council in their responses to some of those.
Well, one of the main things we're involved in, obviously we attended the charrette in 2012, and also the sort of public engagement or exhibition in 2016, and at that event we had a number of discussions with members of the public in terms of their concerns. I mean, from our perspective, one of the main things that got mentioned was in relation to sediment management. So I think ourselves, and also I think there was a colleague from the Tweed Forum who attended. There was a physical model outlining the concerns or issues with dredging. So that was the main sort of public engagement that we've been involved in. But also there's been a number of, we've had a couple of meetings, or at least one meeting or telephone conversations with members of Save Our Sands as well, and there's been a number of other sort of, you know, freedom of information requests and things from members of, or from the members of the public in Dumfries that we've been involved in.
But when SEPA is preparing a response, either informally or formally to an order, you wouldn't do a consultation with the public in advance of that. It would be your response, would it not?
Yes, sir, that's correct. We have a duty to respond to the local authority if we are consulted. We're a statutory consultee within that process. Basically, the response we make will be based on information we both hold and our knowledge of flood risk of any particular area or catchment, and also the information we receive. So, for example, the Council's model as produced by Michelle. That's not to say, however, that the information we hold may not be information that's been presented to us or sent to us by members of the public. For planning applications, it might be contentious. We often get photographs and things sent to us, and that is information that we can take into consideration. But we don't have an obligation or a duty to proactively engage with any other party other than who is consulting us. So I think, as my colleague said, under freedom of information, under the environmental information regs, people can request information and opinion from us, and we have provided quite a lot of information to certain members of the public prior to this hearing stroke inquiry, and also over the years of our involvement in consultation for this scheme.
Okay, Mr. Dowson, I thought you had your...
Sorry, I've got various people, I think, wanting to comment. I would like to comment myself, but perhaps I could leave that till the others.
Yeah, I'm just before you do. We'll hear you, and then we'll stop for lunch. Just remember the context that we're here. It is a hearing to understand the policy and the legal background. I wanted to understand the roles and responsibility of SEPA. We'll do the same with the other organisations. You heard my questions. You've heard Mr. Mundell's. So I hope they're going to be quick and focused.
Well, yeah. Could I, in preparation for this hearing, I did submit a document to you with around about 20 odd questions. Yeah. 52. Thank you. Yeah. Okay. Yeah, right. The fact that there are 52 questions show you just how badly informed we are. I'm probably one of the best informed people in the Dumfries community about this. I think I've read about just about every document that's there. And I've still got 52 unanswered questions. And that's a reflection of the fact that the community, people like myself and others, have simply not been engaged, not been involved, and that's coming out now. By the end of this hearing, I want an answer to all of those questions. I don't expect to get them today. But I would invite SEPA, Scottish Water, HES, to a separate meeting with Whitesands, perhaps, to try and address some of these issues, to try and make it a little bit easier. Maybe I could just continue with my bit, and then, if you will allow one or two other people to speak. Just in response to one or two things that SEPA said, and I'm just responding to what was said, I wanted to just ask about the freeboard calculation or involvement. My understanding is that SEPA's recommendation is some 0.5 to 0.6 of a metre. Is it the case that that has been reduced in the scheme to 3.3 of a metre? I have read that somewhere. And if that is the case, I would want to know why. Do you want to answer that one first?
I will, but before we go on, before we go on, I understand you have questions of SEPA. I've seen your 52 questions.
Right.
And my difficulty is that this is not the appropriate format for a formal question and answer session. There's nothing stopping you or anybody else approaching representatives of the various organisations and asking for information. We don't need to do that at this hearing session. I also want you to bear in mind that we do have a technical inquiry session where you can put questions to the actual promoters of the scheme, which are the council and its advisors. So I don't want us to waste inquiry time, and it must also be fair to the officers of SEPA. So I'm going to collect your questions before I decide whether I shall let you have them. So you've asked a freeboard question. What's your other one?
Well, it follows from Mr. Mundell about option appraisal. As far as we're aware, there only ever has been one option that SEPA has been properly asked to look at. The other options may have been put forward by the Council, but they did not have wide and broad support, and we think they were engineered to be just not acceptable. So we don't think that SEPA has ever been involved in a complete option appraisal. With regard to the calibration of 2015, we agree with Mr. Mundell that you cannot recalibrate a model based on one flood and at one time when you go out in a boat or whatever to look at things. We have, looking back over the last 20 years or so, we have seen many models from Babte in the 80s through to Jacobs 2007 to Michel's original model to now a recalibrated model. We have been told about models all day long, and none of these models, as far as we're concerned, they're interesting, they give a bit of guidance, but the river is different, the river is real, and the models do not necessarily bear a relationship to that. One other thing that hasn't been mentioned is the whole climate change factor, and with all the pressures on that, we understand that SEPA, I think there's a suggestion of a 20% figure that has to be put in, and as far as I'm aware, the Council proposal does not have a climate change factor in it, and perhaps they could clarify that point. And as I've said, there's one or two other people on our side, I think, wanting to ask questions.
Well, can I collect them? I don't want this to slip into 52 questions, because we don't have time for that. So what other questions? And I have some concerns, some of those as well, but let's hear the others.
I'd like to ask SEPA a question. That's it. I'd just like to ask SEPA, has your flood warning system ever failed in Dumfries when you put the figures out on the internet? I'd just like to ask that question because I believe it has failed. I remember one day there was no flood warnings yet, we were under 2 feet of water. So that's one that I'd like to ask. Another, regarding the tidal situation, the tide in a lot of cases doesn't really have a great deal of effect. Because I remember one day the tide came in at 2 o'clock and the Sands car park flooded and it all went down the river, tide went out. But at 6 o'clock that night it came back in and there was no tide and it flooded. So there's a lot of variations in that river. Also your display in George Street Hall was just like a little box with some water and sand in it. And that really doesn't really cut ice with me, I have to say. So that's my questions. I think that's the more I had to ask. Yes, and we had to also ask for a meeting with SEPA. We weren't offered a meeting, we had to actually come to you, John and I, for a meeting with SEPA. So that's my questions. Thank you very much.
Well, I'm not sure some of those were questions, to be honest with you. Was there anything else from Save Our Stats? So I'm going to go through these in a minute, and I'll tell you which ones are questions and which ones aren't.
Thank you. Hydrology. We know the river's tidal up to the coal. Hydrology and the wind factor, the storm factor. Every major flood in the neap tides and the spring and winter tides, when you've got a 60-mile-an-hour gale behind it, I can imagine all your normal hydrology goes out the window. Do you take into consideration these factors? And the final point, reporter, when these cohorts of experts leave, how can we have a meaningful discussion, as we're perhaps having now, when these experts have gone away? They won't be back till the 7th of December. Thank you.
Well, I'm going to answer that one. This inquiry is into the objections made to the order, and the promoter of the order is the council. All the other organisations are merely consultees. And we have sessions set up where objectors may ask questions of the council who are promoting this scheme, and I understand they have a witness who is their modelling expert, and you'll be able to ask those questions then. So I think rather than try and unpick a very complex model today, we can postpone those questions about the tidal and the wind and the like to our detailed assessment when that's been set aside. That was that one. I hear all your opinions, Mr. Slater, and it's noted for the record. I'm not sure there were questions behind those, though, so we can forget about that. I do think it was a fair question about the freeboard. What was your question about the freeboard, Mr. Dowson?
Be wrong, but in reading I understood that it would be normal for a freeboard of 0.5 to 0.6 metres to be recommended by SEPA. I have read that it's been reduced to 3.3 of a metre in this case. Is that correct? And if so, why? And perhaps if you could just tell us what freeboard allowance is actually in this scheme.
Is there an easy answer to that?
Hopefully. I think there was a question about freeboard and about climate change, and if I could maybe take them kind of together and hopefully make sense why. The recommendations we make around freeboard and climate change are predominantly for planning developments when you're talking about new developments of houses and buildings. And I think the key thing to keep in mind is it's a recommendation for the most part. When it comes to that, albeit in certain circumstances we will require the board to meet a certain design level, but that is for development of buildings. So normally, yes, 500 to 600 millimetres or 0.5, 0.6 of a metre is our normal recommended advice, which is a kind of industry standard. However, in this case, the council and their consultants have used a particular method that was derived by the Environment Agency, which is a far more detailed method looking at the specifics of a model and taking into account the cost-benefit along the length of the model. So, yes, if they have went for a different figure, that is based on a standard methodology, and as the Flood Prevention Authority and promoter of the scheme, it's within the Council's gift to do that. With climate change, what you have to understand is there's no legal requirement for climate change to be taken into account in the design of a flood prevention scheme in Scotland. That's a question you'd have to ask the Scottish Government if you wanted to know the ultimate answer to that, sir. What the Scottish Government hope to do is a managed adaptive approach where they would prefer flood prevention schemes to have a degree of flexibility in that they can be hopefully raised in future. And what they mean by that is if you build walls higher and higher and keep adding big allowances of climate change in now, then basically you can actually topple over the cost-benefit equation and not make it economically viable to build. So for the long-term sustainability of the protection of existing development, existing towns like Dumfries, they would prefer a scheme that could be raised in future. What you have here, of course, is a scheme with a degree of permanence to a certain design level with demountable walls that can go on top to raise it up. And possibly in the future, those walls that go on top could be made higher. I don't know. But I think the key thing to understand is that with climate change, there are new figures all the time, and there's about to be new figures published very soon. But for a flood prevention scheme, there is no legal requirement to include them in the design of a scheme.
Okay, are we done?
Okay. One more question to SEPA. It's a general one. With regard to the document, SEPA's technical flood risk guidance for stakeholders, SEPA's requirements for undertaking of risk assessment, it says there should be details of structures, including culverts, embankments and walls, and how they might influence water levels. These are minimum requirements. So my question is, have they been met to a degree that would satisfy the ministers and the public? The documents I've read the Romoshell and the Scottish Water reports don't satisfy me, or others on that point, and yet SEPA accepted this work. Do you have any comments?
Yes, the document you refer to, sir, is not actually the document we would look to in terms of assessing the model of a scheme. That document is actually for development of properties, and they are the structures that have to be taken into account within a flood risk assessment, which is a model of open channel flow, taking account of culverts that can block, bridges that can block, which then can cause water to come out of bank of a river and actually flood an area that may be promoted for development. As my colleague pointed to earlier on, and as the reporter has given us on the tablet, it's the flood modelling guidance for responsible authorities, which is the key document that we produced a few years ago for this particular purpose, that gives guidance to local authorities on the kind of standards we'd be expecting to be followed for the design of a flood prevention scheme. They are two separate things.
Thank you. Okay, that's done then. Any further? Are we done? I'm going to break there for lunch, and when we come back, we'll start with my questions for Historic Environment Scotland. If we can come back for 2:15, please. Just before we start, just a couple of announcements. You will recall that whilst there were questions to SEPA, they were going to give me a reference, and the relevant reference is page 84 on document 26, which is flood modelling guidance for responsible authorities. We're also receiving feedback from people who are watching us at home. There are 50 people watching these proceedings, and they have texted the DPA to say that sometimes they can't hear if you're not close to the microphone. So it's just a wee reminder to please use the microphone. Right, we're on item 5 of the agenda, B. So I'm now going to ask Historic Environment Scotland some questions about their roles and responsibilities. So can I just ask, in the general case, how does Historic Environment Scotland assess environmental impact assessments that they're given? What are you looking for?
We would review the scheme, and we would look to see if there was a cultural heritage impact assessment as part of that, and we would have a look at any visualizations provided, potentially request further visualizations, look at the cultural assessment to see if its conclusions and method were clear and sound. We provide comments on that. That's so just to clarify, we'd look at the methodologies as well as part of those things.
Would that be primarily desk-based, or would you do site visits, or does it depend?
It would depend on the nature of the scheme.
But in this case, was there a site visit, do you think?
Excuse me. We have conducted some site visits. A predecessor case officer who handled the case has visited the site and consulted with local community groups as well in Whitesands, and met with council and their agents to discuss the proposals. And we were consulted in a desk-based exercise in terms of the scoping at the earlier stages, and then we were consulted on the draft HIA But site visits have been undertaken as part of the general advice that we've been offering to the council and their agents, both in terms of the EIA process, that's environmental statement, the emerging environmental statement that we were consulted on, and also in terms of scheduled monument consent, anticipated application for that as well. But that's been conducted over since, well, between 2010 and 2016. There's been various levels of involvement.
Okay, thank you. That's that done. And in general terms, would Historic Environment Scotland see its role to, for want of a better term, screen out proposals that would give you difficulties in granting scheduled ancient monument consent or listed building consent? Or would you just give general advice?
We would be offering general advice, but we would also be highlighting areas of concern, and we, for example, if we were offered an options appraisal, we would assess those in various ways. So, for example, the monuments team would consider impacts on scheduled monuments and potentially highlight a need for scheduled monument consent, and we would also look at it in terms of our statutory role in terms of as a consultee for listed buildings as well, and we would package that in one piece of advice that would generally be curated by our SEA or EIA teams rather, and broadly curating that as advice and sort of pathfinding as well in terms of scheduled monument consent and highlighting required processes for the future. But as much as possible, we'll be offering advice in terms of what impacts may be problematic and which options might have lesser impacts, for example. And we'd be offering advice in terms of where any, in this specific instance, where we have identified some adverse impacts, what mitigation should be considered and what justification might be required to accompany any forthcoming application to mitigate any adverse impacts.
Okay, thank you. And am I correct that because you're not a statutory consultee, you have no formal position on the flood defence order itself? You have given advice on scheduled ancient monument consent, but you wouldn't issue a view on that until you've made a formal decision. Is that fair?
That's a fair assessment, yes. We don't currently have a position because we've not been asked that question in terms of being presented with a final scheme. We've been consulted on emerging environmental statement and draft heritage impact assessments and offering our usual pre-application advice in terms of anticipating a application for scheduled monument consent. We offer advice in terms of our pre-application process. We do identify issues that may cause concern in the scheduled monument consent process, but obviously we don't want to prejudice any forthcoming application by coming to a view, so absolutely not. We would not state what the likely outcome would be, but it's also difficult to do that when we don't have a final scheme to discuss on that.
Okay, thank you. For the Council, any thoughts or comments on what you've just heard?
Only to point out that in paragraph 2.19 of the hearing statement for HES, there is a narrative of the most recent sequential involvement at the end of December and their position at that point is recorded there.
If I may also add that, yes, in particular, documents HES 5 and HES 6 are perhaps the most relevant in terms of our advice. In HES 5, in our letter, we outline specific documentation that we'd require to accompany an application for schedule monument consent. We also noted concerns, for example, at that stage of the heritage impact assessment, and noted that some of those had been addressed by the time of our letter of December 2016, which is presented in HES 6. But there we again discuss the information that we had not received at that point.
Okay, I take it Scottish Water, SEPA have nothing to add. HES for Save Our Sands. Any thoughts or comments on the role and responsibilities of Historic Environment Scotland?
Yes, if I could just comment a little. As far as we're aware, I don't think you've been involved in any options appraisal. As far as I'm aware, you've only given advice on one particular scheme, that's the scheme before us. Perhaps that could be clarified.
Yes,
we have been consulted on a draft scheme. We noted that the scheme had been amended at one point to change the flood levels predicted, but we've not been presented with an options appraisal. That's one of the documents that we have requested that, to support an application for schedule monument consent.
Okay, thank you, because you used the words that there are adverse effects of the council scheme and that's involving mitigation. Our stance, as I've said earlier, is that that's contrary to your policies. I won't go into that in detail just now. I'm sure that will come out later. Just looking at your statement, paragraph 214, you mentioned that the scheme would require a formal application. We're surprised that has not been done, because if we look at that, that paragraph 214 relates to 2010. Paragraph 2016 relates to 2014. Paragraph 2018 relates to 2016. So for that 6-year period, there was the opportunity, and we are still at a bit of a loss as to know why an application has not been made, because if that application had been refused at an earlier date, then we probably wouldn't be sitting here now. Or certainly that's my view on it. And you say under paragraph 220, for avoidance of doubt, that there is no you have not received any application. One of the problems we've had with the correspondence is that when we have raised this with the council have been implying to us that HES approves of this. In other words, that it's almost a foregone conclusion because of the dialogue that's been going on over that period of time and the communications, that there's also an implied approval in there. And we think that your agency should be made aware of that that's what's been basically said to us, and we think that's premature. And we noticed under particularly paragraph 4.1 that you mentioned that such approval in some cases would only be given in exceptional circumstances. And we are not aware of exceptional circumstances with relation to this scheme, and that all of these things, I say, are relevant, etc. So just with these comments, we don't think that the council should be indicating that everything is okay, because there hasn't been an options appraisal that's gone. We believe there are other options which will comply with your policy and will be much more preferential in terms of the historical setting and of the structure itself. We think they should be brought to you, and we will be arguing for that later on.
Thank you. I look forward to our discussions on visual and heritage impact. Are we done on the role and responsibilities on Historic Environment Scotland? Okay. Scottish Natural Heritage. Sorry, Mr. Ferguson.
So are we dealing here exclusively with the scheme? Will we come on to potential further involvement of HES? Or are you satisfied with the explanation already given regarding the further consents?
I was. Your questions just intrigued me. Under item 6, I wanted to look at various scenarios, which may well have an implication, and if that's what it may be better if you deal with that under there. If there was something else that we've missed.
No, I was looking ahead to section 6. So.
Yes. So Scottish Natural Heritage. Similar questions to you, really. In general, how does SNH assess environmental impact assessments? What is it that you look for when they come into you?
Well, as with other statutory consultees, we will be engaged at a scoping stage where the council, in this case, would have asked us, what are the sorts of issues that we should be considering if we were going to go ahead and do something like this scheme. And we provided advice on these are the sorts of natural heritage impacts that a scheme like that could have. And that leads to our advice on recommended surveys that should be undertaken to determine what species are present, and also gives us an opportunity to set out, potential. Well, we set out the survey requirements at that point for them to inform their own environmental statement. They then provide us with a statement. Our case officer will review that statement and review the survey work that's been undertaken and determine a few things. One would be whether or not it might have a likely significant effect on a designated site, for example, the SAC, or whether there are species of conservation concern, whether it be otters or bats or whatever happen to be. And on that basis, once we have that understanding about what's present, we then provide advice about our position and a way forward. So we might be suggesting mitigation. We might be highlighting, as in this case, that they might want to do, if there was material being removed, for example, that the timing of that material would need to be removed at a certain time to minimise impacts on something like river lamprey or sea lamprey, and also signposting them to other organisations, for example, the Nith Fishery Board, who have more specific information about those species to seek their advice on exactly the minutiae of the detail about when to do that. And we would also cover the licensing issue. And in a nutshell, essentially, like I mentioned before, under the conservation regulations, we'd be saying, if, for example, there was an otter hold there which we think is going to get damaged, then you're going to require a licence for that. But we won't deal with the licence issue now. We will deal with that because actually we might be consulted several years before any work actually happens. So there's no point in us going through the licensing process as per the legislation now. Let's do that later on, because you also need to do another survey to determine closer to the time of pre-construction whether or not the species are still present or not. Typically we would accept survey work which is 6 months old, that sort of thing. Once it gets beyond 6 months, we start to say, well, actually maybe you need to consider repeating your survey work. We don't necessarily indicate at that stage whether we would approve a licence if it was applied for. However, if we had serious concerns that we'd be unlikely to approve a licence, I think we'd be flagging that up to say, guys, you've got quite a big issue here, which isn't necessarily going to be a standard procedure, once you've got permission or consent to actually go ahead with the scheme. So in this case, we don't have those concerns, so we weren't we weren't flagging it up in that way.
For the council, any thoughts or comments on what you just?
No, sir.
For Save Sands?
Just to confirm that salmon and sea trout are included in this licensing and wellbeing process. Being a salmon and sea trout river with the considerable financial ramifications of that.
Salmon and sea trout, I don't think are licensed. They are not a listed species in the conservation regulations, as far as I can remember, although salmon might be. I can check that for you. I'll check that for you right now, actually. Hold on. I don't have the list of species here, sorry. Either way, the mitigation that would be required for salmon, sea trout, sea lamprey would all be pretty much the same. In particular, you'd be talking about if you wanted to move material within the river, do any river works, then actually you'd need to consider the timings of that, how you're going to go about doing that. For certain species, you would require a license to be able to electrofish to catch and remove them to keep them safe to another location. Yeah.
It's not working, is it? Yes. Oh, yes. Okay. Also, the consideration that being a migratory species, you get the spring run, you get the autumn run. It's not just a matter of a window of opportunity. It's a considerable, particularly when they're talking about rebuilding and consolidating and retaining banks and what have you, that I'm sure the fishermen of this area will have a lot to say about it.
Yeah, I completely agree with you. My view is the fact of the matter, it is exactly a window of opportunity which we and, for example, the NIST Fishery Board would be advising on to say, actually, if you're going to do this work, here are your windows of opportunity within the calendar year where you can absolutely minimise damage or impacts on species. So if you want to do the work, then this is what you should be aiming for, to try and time it in with that. For species which require a licence, we could actually put that as a condition of licence to say, this licence is only valid if you undertake the work within these set periods. And that's fairly standard across the board in a lot of different things across the country, riverworks in particular, which developers do understand and work to fairly regularly.
Okay. Any other comments about the role and responsibilities of SNH?
Just one question or query. It's about the removal of land under the 6th Arch at Evergilla Bridge. Would that require a licence in terms of removal of that land? And would that normally be given, or is it only being given as an exception because of a flood prevention scheme?
Well, my understanding of what we've heard today is that there is a licence required from SEPA, what I heard today was that they would assess such an application on its merits and against their guidance, which is all before us. And are we done on the roles and responsibilities of SNH? Okay. Scottish Water. In general, when you're consulted on a flood defence scheme, what is it that you look at?
Well, first of all, we typically look at what assets may be impacted, and then once we have an understanding of that, we'll then look at the tools that have been used. such as the river model. We have also hydraulic sewer models that have been used in this instance as well. And then we look to see, are they a suitable tool to use, and what changes may be required to update them to make them a suitable tool. Once we've established that, we'll then look at the baseline performance of the current network. We'll understand the boundary conditions that's been used in the river model and also the sewer model. And then we would typically then look to see, we would run the proposed development through these models and see what the impact would be on our assets, and then we would review that against our policies and level of service agreements that we would have in place.
Now, as I understand it, this order includes work to your asset. Is that something that does the order force you to make changes to those assets, or is that something that because they're yours you can pick and choose whatever the order says, whether you would undergo it?
Depending on the flood scheme, if the flood scheme was to change in any way, we would have to then review it and see what's the impact on our assets then. So it's quite dynamic that we would suit, or we would change the assets to suit the scheme that's been proposed. So it's not really fixed upon us to do anything. It's just how does that affect our assets, and would we need to change them in any way so that we could still meet our level of service for our customers.
And what's the service levels that you mentioned there? What are the parameters that you feel that you have to meet?
Well, we typically have service levels for flooding of our customers, so internal, which Steve mentioned earlier on, external flooding as well. We have the environmental impact of our CSO spills, combined sewer overflows to the water body.
In relation to this order, am I right in thinking that the idea would be that the council or the government would be funding the actual changes to the assets, and then they would hand them over for you to take over? Is that how it works, or is it?
I'm not fully au fait with the funding. I'm more the technical to look at the hydrology and that, but as far as I'm aware, I think that would be the case. I don't know if Steve wants.
There's been discussions taking place about that, and funding is a part of the grant available to the council, who would be funded for our asset relocation from that.
Okay, thank you very much. Council, any thoughts or comments on that?
No, sir. These matters are and have been under discussion, and our understanding of broadly what you suggested would happen is the understanding here.
Okay, any comments on Scottish Water's roles and responsibilities for Save Our Sands? Any thoughts or comments on the role and responsibility of Scottish Water?
Well, yes. Obviously, that's a very significant role. It's long been understood, I think, that you can't build a barrier on the surface without resolving some of the drainage and sewerage issues in there. And we think that they are very large, in fact. Going back to the Babty report, Part 2, which was 30 years ago, that laid out works that they considered at that time needed to be done. some have been done, presumably, in that 30-year period, but it's very important. Could I just refer to your hearing statement, just one or two points from that, if I may? Under paragraph 4.1, you mentioned that you had no records of flooding being an issue in the Whitesands area. Now, we understand that. That's partly to do with masking and things, but we found that quite interesting that you had no records of that. Do you want me to stop? There's about 4 or 5 points. Do you want them all or one at a time? Or?
Usual rules, Mr. Dowson. If you've got a series of questions, I want to hear what they are first.
Them all first, right.
So, because I do want us to make sure that we focus our hearing today. I appreciate that you have all sorts of concerns about things, and that's fine. You're allowed to have that. But you need to remember that we have an inquiry session on technical matters, and the council have their sewer experts coming along. So you'll be able to ask the detailed questions then.
Right.
So I really want you to focus on matters that are relevant to this hearing session. So if you've got 5 questions, you better run them past me now.
Okay. Paragraph 4.1 referred to a text that you required in 2016 to be included in the Council's report. Are you aware of whether that text was? My understanding is that that text was never included. If I can just quote a little bit from it, it said, currently there is insufficient detail for Scottish Water to comment fully on the proposed solution or the associated cost estimate for the combined foul and surface water element of the holistic flood alleviation scheme. Our view is that there isn't, we agree with you, that there is no detail, and one of the big problems we have here is that the whole drainage proposals are completely inadequate for anyone to comment on. You comment later on here, under paragraph 8, that there are no objections. Scottish Water are not aware of any objections to the drainage solution. Well, that's true, because we haven't seen a drainage solution, so how can we object to it?
And your next one?
Well, my next one, right. Let's see. I wanted clarification of the role of Mr. Rob Sharp, who's one of your witnesses. We understand works for Michelle, and we're a little bit confused as to how a Michelle employee can be a Scottish Water witness, but just like a wee bit clarification on that.
Any party is entitled to introduce any witness they want. My understanding is Mr. Sharp is Michelle's, and now WS Atkins, he's their sewer expert, and he's giving evidence to us at the technical inquiry session. So if there are technical issues that you want to ask, he's the man to ask, and it's that day, not today.
He's not working for Scottish Water, though?
I don't think he works for Scottish Water, no.
Thank you.
So just to make clear from the Council's position, the position is that there was a request for Mr. Sharp to be made available for this session, and the Council asked him to be available for this session. And that's the long and the short of it.
My concern about the text question is that our inquiry is into the order that is before us. We can't go back in history and look at what decisions were or were not made by councils or councillors. That's history. We have an order, and the only question is, should the Minister confirm it or not?
Let's come back on that just for a moment. Okay, let's not go back in history. Let's talk right now. That's what Scottish Water said a couple of years ago, that there was insufficient detail for Scottish Water to both cost, etc., and comment. Is that still the case?
Any schemes go through a process of outline design and detailed design. At that time, the proposal was put in front of us. There was enough detail on the table for us to make a decision, but we have to be fully aware that there'll be ground investigations, which may alter schemes slightly. Once we find out where the utilities are everywhere, that leads to change as well. So the outline design was fine, but we gave the statement to say that we understand that there may be changes going ahead, so that we couldn't clarify that at the time.
Okay. Thank you. And just if we're a wee bit patient, when we come on to item 6, we'll be looking at the processes about the orders, and so there may be scope for us to understand what's happening there. Anything else, Mr. Dunn? Okay.
Thank you. In terms of hydrology, in the plan submitted with the council, there's a provision for an underground reservoir in the location of the market on the Whitesands. Now, given that the capacity of this would appear to be a 240-minute storm, a 4-hour storm, over Dumfries, let's assume 100 millimetres an hour, 4 inches an hour, what in your hydrological calculations in cubic metres will be the amount of water deposited on Dumfries? Because it seems from what I see from the drawing, it's utterly inadequate, this pumped system.
Well, again, that's an opinion rather than a question. I'm happy to... Right, okay. Can you point us to the documentation which shows us that? The modelling report. Have you got a document number there you could... Scottish Water's document number 1. Thank you. Does that answer your question?
Two very brief questions. Simply, has there been a comprehensive drainage assessment? Secondly, Scottish Water state that the drainage network is working in full capacity. What does this mean?
Very easy answers to those two questions. Number 1 again, Mr. Miller.
Yes, has there been a comprehensive drainage assessment? I'm thinking of the likes that appeared in the BAPTI report in 1983.
Given I've not seen the BAPTI report of 1983, I don't know what details were covered there. However, we have a drainage model, and it would be tested against the level of service that the scheme has proposed to work against. I find it hard to what would you class as a comprehensive drainage study. I think that's the question I would need to understand.
Okay, and the second question? See what is full capacity?
What does it mean? What's the condition of the drainage network?
Well, the drainage network would be passing flows as we would expect through the treatment plant, and it's performing as we would expect and meeting all our treatment objectives and environmental objectives.
Okay, thank you. Any other points?
Just one last point, and it is on the funding of the scheme. The question was asked about government grant. Government grant only relates to 80% of the costs. A further 20% would need to be met. I have it on an FOI from Scottish Water that you have not budgeted any money for the Whitesands scheme. Is that still the case? In which case, where does the 20% come from? If Scottish Water haven't budgeted for it, the council at a meeting last week, Mr. Speedy, who's present, said that the council might spend the money and try to recover it from you. And if I'm misquoting him, he'll put me right. But as far as I'm aware, you haven't budgeted that 20%. As far as I'm aware, because of what we talked about earlier, you haven't costed this scheme. We don't know what this scheme is going to cost. So where's the 20% coming from? Because my understanding as an ex-councillor, I always used to get advice that it would be potentially illegal for the council to fund Scottish Water activity. I think there's a serious problem about the funding which is unresolved.
Again, we've got witnesses in the technical session, which there's a quantity surveyor coming from the council. You can ask questions about that as to what's been factored into the cost of the order. Perhaps I can rephrase your question to say, are Scottish Water making any capital contribution themselves to the works, to your assets as a result of this order?
When it comes to service relocation, Scottish Water wants to remain cost neutral.
Does that answer your question? Yep. Thank you. Right. I think we're done on roles and responsibilities. Can we now move on to future process? So, again, just for us to get our head round the various procedural implications of all this. And we'll start with A. In the event that Scottish ministers confirm the order that is before them, I'll start with the council. If that situation was to occur, what are the next sequence of events? What has to happen following the confirmation of the order?
So, to some extent, that might depend on any associated conditions which dealt with any detailed matters, for instance, of design that were relevant to the overall construction. That would be the next logical pause point immediately after an order was confirmed. But subject to that, the anticipation is the scheme would then proceed towards tendering and construction.
Pat, I obviously wasn't clear, but there's the sort of things, what has to happen to make it happen. So in my own head, I thought, having got the order approved, you would then have to do more detailed design work. You would perhaps you'd have to discharge any conditions. Perhaps there would be other consents. Then you'd have to go out to tender, that sort of thing. So keep me right. What are the exact sequence of events? Well, not exact. What are the basic sequence of events that you see happening if the order is confirmed?
Once the order is confirmed in any period provided under regulations for it to be notified and so on have passed, you're right, sir. There are some elements where more detail is required, particularly on some of the surface treatments and so on and so forth in relation to the embankment. So work would need to continue or develop on that to try to produce a final version. That might in itself then, this is where it becomes slightly circular, become regulated by conditions. If a condition was imposed dealing with how that particular sequence should proceed. So it would be anticipated that you would then move from having the order to confirmed to dealing with any remaining detail, such as the ones I've mentioned. Issues like scheduled monument consent could then be approached as well. I would anticipate something like CAR consent for the removal of the berm would probably come slightly later in the process, because that would be associated with the actual physical works taking place. But it's not absent those steps which were required either to complete detail or to meet conditions which might in turn deal with that detail. Nothing further would be required. I'm reminded that before the actual construction process started. I think you heard earlier about pre-construction surveys for any change in the wildlife baseline in case some step other than is currently envisaged was then anticipated. So it's really anticipated. It's very much down to the detail, insofar as the detail has not been reached. So that, for instance, in relation to shed to monument consent, because there's already been a lot of work done, a lot of it in significant detail, there might be less additional work to be done on that, subject to the requirements of the appropriate authority at that time.
Yes, so at some, it would be fair to say that if the Minister was persuaded to confirm the order, then the Council's project team would have to sit down and work out a more detailed project management plan of all these various things. But you set out the basic sequence there. Is that fair?
Yeah, I'm not in a position to say, sir, at this stage, where, for instance, tendering for major construction work would fit within any particular timeline, because at this stage it's premature for me to give any view as to precisely how it would sit in relation to clearance of conditions or any other particular step. But because the essential features of the scheme in hard terms are in the scheme, it's anticipated that the amount of detail is relatively limited.
Okay, before I go over to Save Our Sands, I'll just check with the other organisations. Any thoughts or comments if the order was confirmed? Anything that would impact on you?
From SUPA's perspective, it'd be regarding the activities that would be controlled under the controlled activity regulations. So we'd want the council to be applying in sufficient time in order that the due process can be undertaken with those dealing with those authorisations. Because if there's a requirement for advertising, consultation, going through derogation process, all that is certainly time consuming and would require a lot of time to do that. So, and obviously the time of year that these activities are being looked to be done would be essentially as SNH have stated as well, that there's only certain times of the year that we'd be looking for this type of work to be undertaken.
So I should be a little bit more conscientious and just go around, particularly for the... okay, another one.
Yeah, sorry, just a couple of other things to add on to what Dave said there. Yeah, I mean, any further detailed modelling or work that was undertaken by the Council, we would, of course, provide them with feedback and response on that if they consulted us on it. There may be planning conditions. Lorna, you might want to say something, but there might be planning conditions we would maybe recommend, or planning conditions be put forward by the Council that they may consult us on. The other thing from our point of view would be the flood warning process. Once the kind of detail of the scheme is confirmed, I think we would have to review the flood warning model, because obviously the scheme is predicated on an element of demountable defences. So the warnings directly to the local authority in terms of activation of the higher element of the standard of protection would be required to make sure that that was as accurate as it could be. Thank you.
Thank you. Scottish Water, anything to add?
Just something similar, that as the scheme details come forward, we would work with the council and make sure it works with their assets and we deliver what's required.
Historic Environment Scotland?
Before, in terms of future process, if the order is confirmed, there's obviously a route of scheduled monument consent, and my colleague James will be talking about that. And in terms of listed buildings and conservation area, my colleague Louisa will be just briefly mentioning that. But before I hand over there, I think it's important to flag up document HES 10, which is a discussion document produced by our designations colleagues who aren't here today, but nevertheless we have this statement to look at. As we're aware, the Devergilla Bridge is both a Category A listed building and a scheduled monument, and since 2015 the designations team has been seeking to remove, where appropriate, dual designation status. The third paragraph of that document, they note that the designation of Dumfries Home Bridge, as it's scheduled, has not yet been reviewed, but where in similar structures and similar processes through the dual designation project, where bridges continue to function as such, as a footbridge, they've generally removed the bridge from the schedule, leaving it as a listed building. And they've outlined that that is a likely outcome for Dumfries Old Bridge. That obviously changes how Historic Environment Scotland would then handle any forthcoming procedure if the order is confirmed. And then, as I say, we can...
Will you pass on to your colleagues, which is, I'm very grateful for you for mentioning that. Is there any time scale that we should be aware of for these things happening?
Generally, the casework team, we don't guide that time scale. We are not aware of a specific time scale that our designation colleagues are working to, but as part of the project they do consult the casework team to see if there's any pertinent issues that they need to be aware of. So, for example, we've highlighted the fact that there is this PLI underway, and my understanding is that they are awaiting the outcome of that, and rather than to confuse the process, that's not going to be imminent. But in terms of timescale for that, we don't know, which is why we're willing to both outline if it continues in its... Obviously, if it continues as a dual designated site, the scheduled monument consent process effectively supersedes the listed building consent processes, and that's why we're happy to outline that process if the order is confirmed. If it's removed from the schedule and remains a listed building, then the listed building consent consultation would arise. But timescales, that's not been outlined in that discussion document.
Okay, thank you.
Just to clarify as well, if we received an application for scheduled monument consent, it would be addressed within that application, within that scheduled monument consent, rather than the works would fall under that regime rather than changing it halfway through or something like that. So just to highlight there that our future involvement will relate to any works that would require direct impact on designated heritage assets. And as we've heard, that includes scheduled monument consent, listed building consent, and demolition of any building within a conservation area. The SMC, we would receive an application, and once we validated that, we would determine it within 8 weeks. And we would assess that against the policies and principles set out in Historic Environment Scotland Policy Statement, which is HES Document 8, Sections 3.14 through 3.22. And also important to highlight that notification may be required. So if it's we may have to notify Scottish ministers, in which case it can take a little bit longer. The other thing to point out is that would, again, only direct impacts. We wouldn't be commenting on the setting of the scheduled monument for that time. All right. Thank you.
So in terms of list of building consent and conservation area consent, the application involves demolition of the unlisted toilet block near Devagilla Bridge. So that would need conservation area consent for the demolition of that. There are also 3B listed bridges, which it's unclear from the information we've got exactly how the scheme touches those, but it's possible that they would also need listed building consent. And similarly, there are proposals near the Bridge Street, the little cottage at the end of Devagilla Bridge. It doesn't sound from the application as if that work actually touches the house. So that might not need, that wouldn't need listed building consent unless it actually touches the building. All those consents would be administered by the council, and we would be a statutory consultee for those. Yeah, and that would be the same if Devagilla Bridge was descheduled. We would be a statutory consultee for a listed building consent.
Okay, thank you. SNH.
I think we covered a good bit of this in my last statement, just about, completing the consent process, more survey work to be undertaken, and the findings of that submitted to us, and for us then to take a decision on whether or not there would be impacts, whether or not a licence would be required, and whether or not there would be any agreed the final details of the mitigation and timing. So there would need to be a bit of an exchange on that sort of detail.
Thank you. The Save Our Sands, any thoughts or comments on what you heard? I know this is not the end that you desire, but in the event that ministers were persuaded to confirm the order, any thoughts on comments on the future processes that we've just heard?
I think the future processes partly would involve conditions. I mean, we've taken the view that this scheme is premature, and we have seen the reasons why it is premature here today, because there's a lack of detail, and that's been mentioned, I think, just about by everyone. It's certainly been mentioned by the Dumfries community, because when the scheme was advertised, we were unable to give objections to things like drainage, whatever, because of the lack of detail. So part of what we would see as a future process is that any minister seeking to confirm the scheme would have to impose a condition about a fully detailed design. The people of Dumfries would be entitled, and I think would demand, to see the detail of a scheme. The council have admitted up till now that this is in an outline design scheme. My understanding of planning procedure, I know this is not planning procedure, you'll correct me, but normally an outline scheme would then have to be subject to a detailed approval. So we would want to see a very detailed approval process. We would not be happy with that being solely left to the council to determine, and we would want that detailed process to be the subject, and I don't know if I'm allowed to ask for this, but if it's being promoted under the Flood Risk Management Act, we think that that detailed application should be subject to a 28-day advert and invitation for objections, because the Dumfries public will want to object to the detail, particularly, if I may say, on things like the drainage and sewerage, which we've got literally no information on at all. So that I think that would have to be advertised again, and that's certainly something we would be looking for. Further than that, if the scheme were confirmed and went further and went on to tender an actual building, we would be insisting upon, with the council, the community to be represented meaningfully in every other decision that's taken from here on in, and that would include being involved in the tendering process and being satisfied about every aspect of that, because we have seen recently what has happened with certain capital projects in this town. And I think the community would be entitled to ask for a place round the table in every decision, not just on the tendering, but what was mentioned there was project management plan. And we think businesses on the Whitesands would have to be given a very meaningful role in that, because they are the ones that are going to experience the massive disruption. So we're looking for a meaningful role for the community, not just to be told what is going to happen to them, but to be actually engaged in the decision making. And I think that's an absolute essential requirement.
Okay, thank you. And of course, our final session will be a hearing session on the 7th of December where, amongst other things, we'll be looking at conditions and the like. Before I move on to what happens if the order gets modified, can I just pick up on a point made by Mr. Dawson there and ask the Council, when it comes to detailed design, who, if anyone, would, for example, check the structural stability of the design as a flood defence fund?
Can I just pick up your point, first of all, sir, about the conditions session? The last point made about the involvement of the community is a topic which is already touched on in the conditions proposed, and there can be a discussion about what view is taken of that. Secondly, the Council don't accept that this is equivalent to the concept of planning permission in principle, which is a recognised concept under the planning legislation. It needs to be borne in mind that the planning permission is simply something that follows upon the confirmation of the scheme. It's not a scheme in principle, it's a scheme. So it would be wrong, we say, to approach this on the basis that this is some kind of red line within which you can put something to be as yet determined, because the main features of the scheme are already in what is proposed. So that's the kind of general point. So far as the checking of the structural stability, no doubt that would be done by consultants appointed by the Council, but there may also be issues that arise during the contracting process as to what requirements the contractors have to demonstrate as part of that process. Now, as we're a little way away from finalising the contract terms for the building of the raised walkway, I haven't got that detail available, but it is to be expected that the requirements structurally of the scheme are important. In particular, they're being designed, as you know, sir, so that the foundations will allow for the possibility of higher defences in the future to meet the possibility of climate change. So the precise strength and nature of these are important, and on the information I have would be checked on behalf of the Council.
Okay, thank you for that point of information. Can we now move on to B? Let's see if we can expedite things. As I understand it, ministers have the option to modify the order, and again we're going to talk about this in more detail in the final hearing session. But are there any, if I can direct this to the Council, are there any limits to the scope of modification? Are there limits between when a modification in effect are so great that it becomes a new order, and therefore the only option would be to refuse what is before the Minister?
Well, I think, sir, you are anticipating something that already is foreshadowed in the exchanges scheduled for the hearings and conditions session, because a number of the proposed modifications essentially involve don't build what you're planning, build something different as yet to be determined. And the Council's position is plainly that that's not a modification as envisaged by the statute. The statute, as I understand it, doesn't impose a detailed definition of, in terms of scale or size or weight or anything else, as to what a modification might be. But certainly the anticipation on this side is that the types of modification which would be permissible would be of the detailed nature rather than wholesale or radical change to what is proposed, because otherwise it wouldn't be the scheme that had been presented to ministers for consideration. Where the boundary lies exactly between one and the other, I suspect depends on the individual circumstances of any particular case.
Right, and summarise that. So if ministers modified the order, in your view, they would only be correct if that was, shall we say, not significant changes, and therefore the Council would take that on board, and the sequence of events would be very similar to what we discussed in the case.
It's a little difficult to pre-guess what might happen, and no doubt any scheme which came back with modifications would require to be considered by the Council on the merits of those modifications, and no doubt it would be viewed in that light. The word significant, because of the way it's used by some of the consultants, may be one to be cautious about, because, for instance, a particular objector may think that the addition of a glass panel where there was previously a wall might actually be significant for that particular objector's interest, but yet in the scheme as a whole it wouldn't be described necessarily as significant, and there are no doubt every variation in between. But yes, the position here is that you can't modify a scheme by creating a different scheme that hasn't been developed.
Okay, well, before I go on to save our sands for the organisations, any thoughts or comments if the order is modified? Anything to add? None? No?
I suppose just to clarify, it would depend on the nature of the modifications. Our involvement would probably largely be the same, unless, of course, the modifications meant that there were no longer any direct impacts on any of the designated heritage assets.
SNH, anything else to say?
No, not really. Just if the modifications were significant, i.e. there was no in-river works, then that might be material enough for us to remove any concerns around licensing and things like that.
Save our sands. Any thoughts or comments in the event that the Minister chose to modify the order?
Well, simply the Act does allow for modification. It's quite clear that's an outcome here. As stated earlier, as far as I'm aware, there is no limit in the statute about what that modification may be. I'm also aware that the Minister, I believe, has the power to instruct that any modified scheme should be advertised for a 28-day period for that reason. If the Minister took the view that there was a significant modification to the scheme, and certainly we would be proposing a modification, we do not necessarily agree that our modification is significant. We think it's fairly minor, because we're only seeking to change, if necessary, one design component of the scheme. But either way, the Minister has the power to instruct not only that it goes back to the Council, but that it comes back to the community, because the community may wish to object or have views on that as well, and that would be the purpose. I'm sure you'll keep me right, reporter, on that. My understanding is that that is why that is in the legislation. It is to allow for, if necessary, a significant modification to be considered. That's why it would be advertised. And we would expect it then to go back to the community, to seek further objections, to go back to the Council, and finally, if there was no objections to a modification that we might propose and there was a consensus, it may well be that everyone would be perfectly happy. And we could proceed with that amended or modified scheme.
I think we'll need to discuss this in more detail at the final hearing session. I'll need to make sure I spend my week off preparing for that eventuality. Let's see if we can quickly deal with the final issue. Can I ask the Council if the Ministers declined to confirm the order, what would happen next from the Council's perspective?
They would simply have to consider their position in light of anything said by the Ministers in making that decision. So, and because we can't necessarily predict what that narrative would be, it's difficult to speculate beyond that.
Anything from anyone else if the Minister declined the order? Whitesands?
Yes, well, obviously, this is the outcome that we are here to try and achieve. But we have thought beyond that, if the Minister did reject the scheme, as we would hope, we would say to everyone that we, on our side, on behalf of the businesses, on behalf of the people in the front line, on behalf of the Whitesands Group, that we would wish to sit down in a meaningful and positive way with our Council to look at what can be done on the Whitesands that might achieve a community consensus amongst all of us. We think that can still be done. So even if there's a rejection of the scheme, I don't see that as being the end of the story. Taking account of all the comments made about the Whitesands being strategically important, needing to be protected, we're not against that. We've never said we're against that. But if the scheme is rejected, we are putting a positive invitation to our Council to sit down with us, although we would state early on that we would only do that in a clear agreement about the community engagement procedures. And we would certainly see that as being chaired perhaps independently and being a partnership between the two agencies, with a view to coming up with a final scheme. It might be a year down the road, it might be 2 years down the road. We would rather take another year to sort this out and get a consensus than condemn Dumfries to a 100-year solution that people do not want.
Okay, thank you. It would normally be mid-afternoon break time, but we're so close to the end. I think I'm really, really tempted to bash on. So can we turn to item 7? And this is just an opportunity for all the parties. We'll go around the table. Are there any overall conclusions about the points you've made today that you would wish to particularly draw to our attention? So starting with the Council.
I don't think there's anything new, sir. I think the position of the relevant statutory bodies has become clear when one combines what we've heard today with the material in the hearing statements. The legislative framework and certainly the Council's position on that keeps coming back and back to the Flood Act. So that remains the Council's position. And most of the other matters where we've touched on policies or other consents, without wanting to prejudge anything, it didn't seem, sitting here, that there was actually that much between the Council and any of the statutory bodies on what needed to be done next if the scheme was to go forward. So it's not anticipated that these raise any substantial issues. I think in many ways the last of the exchanges has been potentially the most controversial because it does focus on the issue of whether the reference to modifications in the Act anticipates wholesale and dramatic change or something less. But I have nothing to add to what I said earlier on that.
Okay, thank you. SEPA? Don't have to, but if you want to, this is your opportunity to do a final word.
Yeah, I think we've covered all the key points that we wanted to raise. I think we're quite happy and satisfied that the work we've done to date vis-à-vis our flood and hydrology duties in reviewing what's been put in front of us. We've done it to the best of our ability. I think the main outstanding issue, as my colleagues have explained, is the controlled activities regulation process that would have to be followed if the scheme was confirmed. Just to say whether the order is modified or the order is not confirmed, we would expect to be available for further consultation if the Council choose to consult us. Ideally, we obviously would like to see schemes that are modified not to fall out with the parameters of the flood risk management plan that's been set, but I'm sure quite confidently that wouldn't be the case, of course. So I've got nothing else to add unless my colleagues just want to follow up.
With regards to the controlled activity regulations, I think just to highlight to the Council really that the sediment management aspect, there's still work to be done on looking at options there on the extent of the sediment management that would be required. So just wanted to highlight that point.
Okay, Scottish Water.
Nothing new to add, sir. I can briefly refer to position if the order was modified. That would simply mean for us to modify our design at the end of the day, or the detailed design at the end of the day. And if the order wasn't confirmed, then it would be business as usual for us. As I say, I don't think there's anything new to add. I agree with Council's position and with SEPA's position as well. Thank you.
Hez?
Yes, we are satisfied that the relevant legislation, regulation and guidance in relation to the historic environment has been identified today, and we are happy to leave it to you, sir, to assess the impact and in due course report to the Scottish Ministers. Historic Environment Scotland is keen to engage on future applications, whether that's the scheduled monument consent application or listed building consent applications. It's perhaps surprising that Historic Environment Scotland wasn't a formal statutory consultee in this process, but perhaps that's an issue for Scottish Government.
Mr. H, any final word?
Not a lot extra, but just to say that I know there are some other ideas which may be brought in or suggested in the hearing sessions or inquiry sessions later on about modifications that could be provided to create additional capacity in the Whitesands area, ideas such as dredging and taking away the island and all that sort of thing, that actually we'd be happy to come to one of those sessions to talk to those issues if needs be, in particular that issue, which is one which, unlike the removal of material in one go, on one occasion, issues like dredging or repeat exercise would need to be done multiple times over long periods of time. So actually, whilst I'm talking about consent or licensing issues in a way that we think we can overcome them, that's not necessarily the case if we were saying, well, we've got to repeat this activity time and time again for time immemorial. So there are issues like that there.
Thank you. That's a very kind offer, but we have a programme established, and next time I expect to see you will be on the 7th of December. That's all. Save Our Sands. Any final points you'd like to make to us for the conclusions that you would like us to take away as a result of today's proceeding?
Well, just to express disappointment, Chairman, that my 52 questions have not been answered, but to extend an invitation, hopefully, to the 4 agencies that are here, that we would like to sit down with you, perhaps out with the hearing here, and perhaps have a discussion about those questions. And that invitation is extended also by 1 or 2 of the councillors, the Fries and Galloway councillors that are here, who would like to offer perhaps a meeting. That would be very helpful to us. I just wanted to clarify, though, one last point. We are not seeking to design a completely new scheme. We think that a lot of good work has been done by all the agencies concerned. I include the council in that, but all 4 other agencies. There's been a lot of good work done there. There is a scheme before us. We don't like it. We would like to see it rejected and replaced with another. If we can't do that, we'll seek to modify it. But we're not seeking to design a completely new scheme. So I really would like to make that point here. We do not have the skills or the abilities to completely design a new scheme. But we do think that we have the abilities here to suggest modifications if that is required. Thank you.
Okay, great. Are there any other relevant matters to discuss? Have we done all we need to do today? I'm looking around. I'm taking that. Ooh.
The next scheduled session for Historic Environment Scotland is the concluding session. I wanted to check whether, in light of today's discussions, there are any remaining matters which may assist you, sir, for Historic Environment Scotland to attend. It's not entirely obvious from the agenda for that session whether there are any points we can assist with, but perhaps you can clarify.
I was keen to have all the organisations around when we discussed modifications and conditions. I appreciate that it may well be you have to stay silent for the whole hearing. You have nothing to say, but I would take comfort from at least knowing that that was the case. If you're not there, I never quite know whether there will be implications. You might want to reflect on who comes to represent the organisation on that basis, but what we will have to recommend to ministers a set of planning conditions, and it's conceivable as a result of the inquiry sessions that we're yet to have, that various suggestions will be made which might have an implication for Historic Environment Scotland. Again, I sense there's a debate coming about modifications to the order, and again, it might be it would be helpful, I think, for you to be there. So I can't add anything specific, but that's the reason that we wanted the full set of organisations present again for the 7th of December.
In that case, we're happy to attend.
Thank you. Okay. Right. Before... Oh, you've been so good, you're allowed to go home early on your first day. So before I let you go home, just 2 points to remind everyone. There were 2 bits of
extra documents that we agreed to be submitted to the inquiry. There was the Historic Environment Scotland setting one. So all you need to do is email the case officer at DPA, you'll know the number, and he will then make arrangements to circulate that round to the relevant parties. And the same goes for the SEPA guidance on catchment. It might be worth your while just to check the extensive documentation before us. I think the council had some documents about, there was I vaguely recall a study undertaken by SEPA, a case study for Upper River catchment. If that was the document you were referring to, then it's already before us. So just have a wee check of the list, perhaps chat with the council. I'm not keen to have more bits of paper, but if there is something we need to see, then please do it. And again, the same rules apply. Just email the case officer and he will get that round. Otherwise, then, we will see you again tomorrow. It will be an inquiry session. We'll make a wee change to the room. It won't be quite the same. But I hope you've enjoyed the opening day. Thank you very much.